Item number 1 for judgment, CRA 182,000, 182,000.
The appeal is dismissed. Time for surrender is 23rd September.
For judgment, item number 2.
The appeal is dismissed. Time for surrender is 20th September. None appears dismissal of this.
Item number 4.
None appears dismissed for non-persuasion.
Item number 5.
My lord, this matter, my lord, no instruction, my lord.
No instructions dismissed.
Item number 6,
My lord, no instruction.
No instructions. Appeal is dismissed.
item number 7,
None appears dismissed. No.
item number 8,
Say,
Right, my lord. No instruction.
no instructions. All right.
item number 9,
Item number 9, my lord, I am on BC, my lord. Here the cause of action, there is no such cause of action subsists, my lord. But I pray I may permitted to ventilate my grievance in subsequent cause of
No,
action.
no, no, no. 2013, you say concept of the appellant states there is no cause of action that's
There is a caste certificate matter. That's why I am saying.
It's all right. Yes.
Plus, no instruction.
item number 10,
None appears dismissed. No opposition.
item number 11,
I may pledge your lordship. I mean VC Mellon. Here is the matter. The cause list shows the counter affidavit has been filed by the opposite partner 1, 2, 3. The copy has not been sought.
It's all right. So tell us what the matter is. It's only a writ appeal.
That the order of the Honorable Single Judge is under challenge on the ground that the Honorable Single at page 14, the unreasoned order. Para 2. May I submit, my lord?
Yes.
It appears the impugned order dated such as that the sub-collector has remanded the matter to the appointing authority to reconsider the matter afresh in view of the circular issued by the government dated 24/11/1997 in its department, Women Child Development Department, regarding selection of Anganwadi helper. Pursuant to the advertisement inviting application from the intending candidate, the Anganwadi helper of Panirpur Anganwadi Center, along with others, have applied for the post. In view of said submission, the Mahila Sabha was convened by the opposite partner number 3 on 11/8/2007, where the petitioner along with 2 others attended in person and submitted application for the post of Anganwadi helper for Panirpur Anganwadi Center. However, the meeting could not be held due to heavy rain, but the selection committee selected the petitioner at project headquarters and issued engagement letter on 14/10/2017. Then, your lordship, straightway come to the last para. Considering the rival submission of the parties on perusal of the record and impugned order, it appears that selection committee, while select the candidate for engagement Anganwadi helper, have not followed the government guideline issued for the engagement Anganwadi helper as per the government guideline 24/11/1997. That para, my lord, as per guideline, Mahila Sabha was convened. All parties were participated. When the due to rain could not held at project level, the selection was held. But for the as per the government guideline, that no reason has been assigned, what guideline has been followed. Here is a point of law. Once a candidate, after participating in the selection process, in accepting the terms of the advertisement, can it be challenged in the subsequent? That is the question here. See
No,
the
no.
arrest.
There's nothing wrong with the order, sir. There's nothing wrong with the single judge's order. This is the correct order. Yes.
But here is the what guideline have violated. Mahila Sabha
Yes, yes.
was convened as per 24/11/1997 guideline.
Yes.
Parties were applicants were participated.
Right.
Thereafter, they could not be held.
All
Then this selection committee selected the candidate on project headquarters. In
All
the 2007, the matter selection was held. Then after the repetition was the subcollector filed after 4 years after cancel the selection, it was remanded. But while select the honorable single judge has everything, no guideline has been followed. What
Sorry,
guideline? That is the
We are not with you, sir. Sorry. The present appeal is directed against an order dated 21st January 2013, passed by the learned single judge, dismissing writ petition civil numbers 22836 and 29303 of 2011, whereby the challenge to an order dated 3rd August 2011, passed by the collector cum district magistrate Kendrapada, in miscellaneous appeal number 18 of 2009, confirming an order dated 11th December 2009, passed by the sub-collector Kendrapada, in Anganwadi miss case number 3 of 2008, was affirmed. Full stop. The sub-collector, by the impugned order, had remanded the case to the appointing authority to reconsider the matter afresh in view of the government circular dated 24 November 1997. regarding selection of Anganwadi helper. Paragraph. As can be seen from the impugned order, the selection took place on a date that there were heavy rains and a meeting actually could not be held of the selection committee. Full stop. When it was challenged by the unsuccessful candidate before the sub-collector Kendrapada in the aforementioned miss case number 3 of 2008, the sub-collector allowed the appeal and directed that the matter be considered afresh in terms of the government guideline dated 24th November 1997. Paragraph. The court is unable to find any error having been committed by the sub-collector in passing the above order. It has rightly been affirmed by the collector while dismissing the petitioner's appeal. The court is therefore not inclined to interfere with the impugned order of the single judge. The appeal is dismissed.
The last part
Item
of
number 12.
not complied may be complied with. That was direction was given to the opposite partner to reconsider the matter. If not complied with that.
If it is not, it's the 2013 matter, sir.
Yes,
We're not doing anything.
election
22.
already completed and another person has got appointed.
Already appointed, yes.
Item number 12.
Your Lordship, item number 12 for no instruction.
No
my lord.
instructions. Appeal is dismissed.
Obliged.
Item number 13.
13, my lord. We have challenged the order of the, as per the annexure 4, my lord, that is page 36, my lord. Direction not to make the compliance 17B of the Industrial Dispute Act. The employee has gainfully employed otherwise in any other firm, money in the LIC. Then we have not complied the orders. They have not filed the affidavit, my lord.
Nothing in
See
this,
the
sir.
page 36, my lord.
There is nothing, there is no stay. This matter has been pending since 2013, sir. We're not interfering at this stage.
Main case is pending for judgment.
Yes, yes, let it come.
Yes, mate.
All right.
My lord. That is the reserve
The
for
challenge in the present appeal is to an order dated 22nd April 2013, passed by the learned single judge in miss case number 511 of 2007,
judgment.
arising out of OJC number 2424 of 1999. Full stop. By the impugned order, the application made by the appellant management for clarification of the earlier order dated 25th February 1999, passed at the time of admission of the writ petition, was rejected. Paragraph. According to the management, sufficient material was placed before the learned single judge to show that the respondent workman was gainfully employed and therefore was not entitled to wages under section 17 capital B of the Industrial Disputes Act 1947 bracket ID Act. Paragraph. Which page is the impugned order?
36, my lord. Yes. Annexure 3, 34 page. Order was dictated in 36.
What is wrong with this order? You're the workman, is it?
No, I am for the management.
No. What is wrong with this 18/4/2013 order?
Thereafter, they are gainfully employed and serving.
What is
any
wrong with this order, sir? 18th April 2013. What is wrong with this order?
Thereafter, we filed the modification order that is.
No. What is wrong with this order? You're the management, right?
Yes, madam.
In 18/4/2013,
Yes, madam.
the judge has said that the workman is not entitled to 17B.
As they are not filed the affidavit, they are serving anywhere in the.
What is wrong with this order, sir? You're challenging this order in this appeal.
Yes, madam.
What is wrong with it?
Wrong is, my lord, he was employed somewhere.
This order says he's not entitled.
Yes, madam.
And you're still saying it is wrong. You want him to get 17B.
Yes, ma'am, he is not.
Then what have you filed appeal against?
They have to file a modification, my lord.
For what? Uh, 18.4 itself, it says that he's not entitled. I don't know what this is, very strange. I don't know. What is the need for that? Oh, there are two different sets of employees. All right. You say from the impugned order of the land single judge, it appears that before the single judge, the present appellant did not state that upon inquiry they had come to the conclusion that opposite parties 3 and 4 were gainfully employed. Full stop. The documents produced were prior to the order passed by the court on 20th April 1999. Full stop. Consequently, the learned single judge was justified in declining to modify the earlier order dated 25th February 1999, requiring the petitioner to pay the 17B wages to the worker. Paragraph, having heard learned counsel to the appellant, the court is not inclined to interfere with the impugned order of the learned single judge. The appeal is dismissed.
Item number 14.
My lord, no instruction.
No instructions, the appeal is dismissed.
Item number 15.
The appeal has become infructuous. I am on BC.
Infructuous. All right. This post off.
Item number 16.
I may please, Lord. Well, the appellant is the SSI registered large scale industry, my lord. Challenge the order of the only single judge, wherein the only single judge set aside the order passed under section 127 of the Electricity Act by the learned appellate authority. The allegation is that, my lord, allegation that there is the excess consumption of electricity beyond the contract demand, and they have inspected the unit on 10/5/2011 and found that there is violation of OERC code 34, 104, 105 and 106. The lordship can see page by kind turn to page 21, annexure 1 series, my lord. The appellant is a SSI registered SSI unit and having his memorandum of articles of association and company, and the page 25 can see these are the purpose for the industry was established regarding rice bran, moga oil, etc. All these things, my lord. And accordingly, my lord, the electricity was consumed from 1999, and which has been enhanced from time to time, and that has been also enhanced, page 26 on 15/11/2003, from contract demand 160 kilowatt to 260 kilowatt. Thereafter, page 27, 260 kilowatt to 340 kilowatt. And also, my lords, while that was in force, and the appellant is using the electricity consumption, lordship can see page 29, the annexure 3 series, the respondent number 1 giving a proposal to the appellant that since your contract demand is now exceeding the contract demand, there will file application under the OERC code 72 of the code for enhancement of the contract demand. In response to the same, my lord, page 30, immediately the appellant submitted his application along with all statutory deposit and indicating page 31, the purpose, place and where the electricity is to be consumed. And during thereafter, my lord, the respondent number 1, the licensee, page 35, has replied on 26/4/2011. And for deposit of the entire other document and the inspection report by the electrical inspector, that has been complied with. During compliance of the matter was stood thus, the electricity bill, energy bill was used raised on page 36 annexure 4 series on January 2011, January, February, and March, April. In 4 months, out of the 4 months, my lord, only the petitioner, the appellant, has a excess consumption of electricity as revealed from page 36 for 29 kilowatt, and again in for February 80 kilowatt. But all the March and April remain the less than the contract demand, my lord. Page 38 and 39. And lordship, page 40. Suddenly, when the proposal is pending before the authority, suddenly the licensee has made an inspection to the petitioner of the appellant's unit and said, alleged that there is extended connection to the adjacent unit of the appellant's factory and violation of code 34, 104, 105, and 106. If my lord permit me, then I can brought to my lord's notice that the how 34 and 104 has not been violated in at all. Basing on that said report, the page 41, my lord, they have the licensee has raised the provisional assessment inviting objection. I filed my objection under annexure 6. Your detailed objection has been filed, replying all the questions raised by the licensee. And thereafter, without considering the same in proper perspective, they have issued the final assessment reports under 126.3 of the page 7, annexure 7, page 50, my lord. And the appellant being agreed thereon, after the licensing of the appellate authority under one section 1 to 127 of the Electricity Act, my lord. The appellate authority, considering the cases of both the parties, my lord, they have set aside the order final assessment and they again switch. The licensee has brought to my lord this honorable court filing the writ petition under annexure, my lord, and double petition number 972 by 2012. And this honorable court single judge, the honorable single judge, has set aside the same, only so the ground that no region has been assigned. But lordship can peruse the appellate authority order passed by the appellate authority. Is my lord, it is a very well reasoned order. And there is, when there is specific allegation against the appellant, is that there is violation of 104, 105, and 106. The honorable single judge only considering the 105 and 106, ignoring 104 of the ERC code and the provisions of the Electricity Act, my lord, has proceeded and set aside the same. Your lordship, for moment, kindly see, my lord, the 126.5.
Yes.
Of the Indian Electricity Act, my lord, 2003.
Indian Electricity Act. This is Electricity Act 2003.
My lord. Electricity Act 2003, my lord. Yes, ma'am. Can I supply my lord one?
In fact, I am for the respondent number 1. If your lordship, my
take it
book
from
is
him.
there.
Okay, it's all right. We have it. We have it.
Yes, yes.
Return it. Return it. We have it. Return it. We have it.
Section 126.5, you lordship, directly 126.5, my lord.
Right.
May I read, my?
Yes, please.
The assessing officer reaches to the conclusion that unauthorized use of electricity has taken place. The assessment shall be made for the entire period during which such unauthorized use of electricity has taken place. And if, however, the period during which such unauthorized use for electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months immediately preceding the date of inspection. Your lordship, the date of inspection I have brought to my lord's notice on 10/5/2011, as revealed from page.
There's a detailed discussion with the single judge.
40. Page 40, sorry, man. Page
Yes.
40, Annex 4 series.
Yes.
Lordship can see during surprise checking on above date, it is found that the consumer has given extended load to a under construction oil refinery unit adjacent to the unit. The consumer has used a black color 35 mm by 3.5 core cable and availed power supply from distribution panel board existing at SNM business own building to the under construction building near about 200 meters, approximately 33 so and so, and the machinery used, and the allegation is that the consumer has given extended load violating OERC code 2004 clause 34, 104, 105 and 106 minor. So far the 104 is minor count. If one person has unauthorized consuming the electricity, then the licensee has power to disconnect the power supply immediately by giving a 7 days notice. But without any such disconnection was ever made, rather the lordship seen that on the advice of the instruction of the page 29 on 5/4/2011, the appellant has made the application for under this clause 72 regarding enhancement of contract demand, which has used to done from 99 till 2011, my lord. In such circumstances, when the proposal for enhancement of contract demand is pending before the authority, the inspection so-called report 10/5 has come out, and ultimately that finality of proposal was accepted by the licensing authority and executed the contract on 30th May 2012. Therefore, the proposal initiated on 7/4/2011 at the instance of the appellant in response to the reply to the licensing authority. They have consumed electricity and paying the higher rate of tariff rate as per the OERC code provision, so and so on. But here the honorable single judge only quoted, ignoring my lord, the OERC code. If my lord has a book, you can see the OERC code 104, 105 and 106.
Why don't you come to para 19 of the impugned order, sir?
My lord.
Page 94, sir.
Man, sorry, man. Yes, ma'am.
Kindly read para 19, sir.
Question number 2, as to whether the spot verification has been made in accordance with law. The stand of the petitioner licensee is that the spot verification has been made in accordance with law, whereas the case of the consumer is contrary to the same. The appellate authority, without discussing the rival contention of the parties in this regard and assigning any reason, observed that some procedural lapses have been committed by both the appellant and respondent in the matter of verification premises and request for enhancement of contract demand, which bears no weight at this stage in view of the core allegation made by the respondent and objection raised by the appellant against the same. No reason has been assigned in support of the above conclusion. There is no detailed discussion as to why appellate authority has come to such a conclusion.
What do you have to say to this?
My lord, my humble submission is the lordship can see the appellate authority observation and finding that the order of the appellate authority itself speaks, my lord. I am being Annex 10, my lord. Page 60 starts from page 61. Page 63, my lord, lordship can see.
Yes.
Dated 29/2011, had perused all documents like the provisional assessment order, final assessment order, spot verification, report of the verifying squad of the assessing officer, objection filed by the appellant, counter filed by the respondent, and written submissions of the appellant, respondent, and other documents during hearing. It is observed that some procedural lapses have been committed by both the appellant and respondent in the matter of verification of the premises and request for enhancement of contract demand, which bears no weight at this stage in view of the core allegations made by the respondent and objection raised by the appellant against the same. The contentious core issue.
No, don't go on reading.
My lord.
Where is this is all conclusion that some lapses have been committed?
My lord.
Where are the reasons for this conclusion?
My lord, the page 64, my lord, that is relevant portion. necessary, my lord, page last para says 63, my lord, from the records as well as the assessing officer in the middle, my lord. The assessing officer have all such cases never objected to permit the appellant to avail power through one service connection on grounds of change deviation purpose. Such thing happened in August 2001, November 2003, and November 2006, when the appellant had been permitted to enhance his contract demand 162 to 260 kilowatt and 260 to 340, respectively, due to inclusion of oil mill unit, solvent extraction unit, and some allied activity in the farm. The assessing officer continued to give supply to farm without execution of any revised agreement, but simply on receipt of additional security deposit in each of those decisions, which suggests that the assessing officer had the latent willingness to continue supply to the farm with not only a rice mill but also oil mill and solvent extraction plant, but had not documented such willingness in the shape of agreement. For non-execution of agreement here, therefore, the assessing officer is responsible, not the appellant consumer. However, in all such occasions, the appellant habitually used to install and operate and added machineries fast, which would lead to maximum demand across the contract demand for a period of as long as 5 to 6 months. He also used to pay penalty for overdraft, and upon detection of such continuous overdraft and on insistence by the supplier, only deposited the additional security amount. He never sought for prior approval of the supplier for such enhancement of load as per the provisions of Regulation 53, 72, 73, and 74 URC Distribution Code. But despite this, assessing officer had never objected on any ground. It was submitted by both the parties during hearing that NESCO have already permitted a power supply, the rice mill, oil mill, and solvent extraction plant, though a single service connection, obviously considering all the above, subunit of the farm as a single unit at different stages. As submitted by the appellant, the refinery unit now under construction will be processing the outputs of the oil mill, solvent extraction plant, and rice bran from the rice mill, which is on activity processed further downstream of that already existing in the industry. Nothing from outside will be used as input raw material to the refinery unit other than those available from existing unit. As regard to the premises with the intention of expanding the existing unit of addition of another processing subunit, that is a refinery unit further downstream of that already existing in the utilizing some output of that existing unit, the appellant has started some civil construction work adjacent to the existing unit premises that is owned by the appellant, none other else. The appellant needed additional electrical power for construction of power structure only during April 2011 onwards for operation of welding machines, drilling machines, and light, etc. in the said refinery subunit. An order had been placed by him with some private agency to carry out the fabrication works of the superstructure on 28 March 2011. He had also applied to the Directorate Factories and Boilers Orissa on 18/4/2011 for extension of the existing solvent extraction plant by setting up vegetable oil refinery unit on examination of MDI, a recording of the assessing officer as such. On all occasions, when he enhanced the loads, the above pattern suggests that the appellant have not assessed his contract demand judiciously, nor coordinated running of the machinery to contain the maximum demand within contract demand level, for which all along used to bear the penal demand charges as provided in the tariff structure. The OAS distribution code under Regulation 72 stipulates that procedure to be followed while applying for enhancement
You're not reading, sir. You're not arguing. You're just reading.
No, my submission is, my lord, my humble submission. Here is a case. The undisputed fact is that there is no provision under the Electricity Act or under the OERC code regularize unauthorized electricity of consumption. But during the subject matter of pendency of proposal, my humble submission, that's what my lord knows, not necessary to enlighten my lordship, because when the special statute is silent, the general law necessarily prevailed as per the Contract Act. Here is a proposal is given to the authority, and the authority considered it, accepted it, and deposits are made. Thereby, the section 62 and 63 will operate, my lord, under the Indian Contract Act itself. My submission is, once you have submitted the proposal for the enhancement contract demand and accepted the same.
You've not executed an agreement also, sir.
Yes, well, ultimately agreement was executed. I have filed written notes of submission.
Finding is that you never signed an agreement.
Your lordship can see my written notes of submission, and that chat I've given you my lord's copy.
Yes.
Lordship, on 30th May 2012 that has been executed.
No.
They themselves basing on that thereby the proposal initiated on 7/4/2011 that attained its finality.
God.
My lord,
What do you say?
regarding the interference by the under 227 statutory proceeding clause, you know, but I have also mentioned regarding that judgment of Haribhag judgment, constitutional bench judgment regarding the honorable single judge has exceeded its jurisdiction. Because here is a case, your lordship, for a moment, how the honorable single judge has only quoted two clauses of 104, 105 and 106, ignoring, my lord, OERC code, my lord, 104. The allegation is that violation of 104, 105 and 106. Lordship, can you see the impugn judgment of the honorable single judge? They quoted that only, my lord, the page 99. On page 99, honorable single judge only quoted, referred to the, my lord, 105 and 106. Had it been there, my lord, unauthorized electricity consumption, the 104 has to be tacked up and given effect to. Here is a case, the licensee never disconnected the consumption. Rather, they have executed the agreement on 30th May 2012, which the proposal thereby attains the finality. In such view of the matter, my lord, my humble submission is there is no illegality, and that important aspect your lordship has seen that 26.5. The 26 categorically says when the date has not been ascertained. Here is the date has been ascertained on 10/5/2011. Therefore, the calculation, whatever may be the demand as per the 26(1), assuming check up agreement, my lord, that is liable to pay. Then from the 10/5, but he has considered the same from last preceding 12 months, which is purely contrary to law statutory provisions.
All right.
Which has not been taken care of by the honorable single judge, my lord.
What do you say, sir?
That in fact, my friend, they are submitted, they have not annexed the agreement for which power supply is provided. I'm supplying your lordship kindly glance. The power supply was provided in 1999 for the purpose of rice mill. Not it has been provided any power supply for the new construction work or the solid extraction plant, your lordship. That has deliberately, that has not been annexed in the appeal memo, your lordship. And repeatedly we are insisting him to for execution agreement. And in order to avoid the payment of a security amount, they did not execute the agreement.
That's what.
That is, your lordship, your lordship kindly class, the 126.5, my lord and friend cited. What is unauthorized use that has been stated, your lordship. 126.5 surplus 6, your lordship kindly glance. Unauthorized use electricity means 6B, your lordship. Unauthorized use of electricity means the usage of electricity by any artificial means or by means of not authorized by the concerned person, authority or licensor, or through tampered meter, or for the purpose other than for which the usage of electricity was authorized. So, for the premises or area other than those for which supply of the electricity was extended. That extension has not been provided to the construction house, your lordship. And the purpose for use I have supplied, your lordship, the agreement copy, that is also part of the record of the writ petition. That provided only for rice mill. That has not been provided for the oil refinery unit or the construction work. That's why the honorable single judge hold that since power supply has been provided for a purpose and you are using power supply for another purpose, therefore it is unauthorized. And it is covered by the decision of Honorable Apex Court Sitaram Rice Mill. Honorable Apex Court elaborately discuss, your lordship, that what is unauthorized use of electricity.
Okay.
Subject to lordship consideration. If you one copy, your lordship kindly glance, then I'll be. If your lordship allow me, I will read this paragraph 29 and 30, your lordship. Your lordship kindly glance. That is reported in SEC, Lord, 2008 basis. 12 basis.
Yes. Yes, please.
In fact,
You don't have a copy.
only
Very
one.
good. Excellent. Excellent. Excellent.
No, not
This is very good, sir. Very good.
power supply.
It's okay,
disconnected,
it's
I
okay.
could not
Yes.
xerox it.
We'll read everything ourselves, sir. No problem.
And
Yes.
that has been cited by honorable.
Very good. Sir.
single
Very good.
lordship.
Very good. Anything else, sir?
My humble submission, my lord, page 30 of the writ appeal, my lord.
Yes.
I have specifically stated the purpose, place, and use of the electricity
Right.
as stated in my application, page 31.
Right.
That is mentioned therein. Your Lordship, can you mark that page 30, 31 might on the response to their application.
All right. All right. Orders reserved.
Okay.
All this. Right.
I'll supply 2 extra copy, Lordship, the judgment.
No. Why are you giving it back?
That is SEC reported.
I'll supply in course of the day, I'll 2 copy, Lordship.
Item number 17.
Lordship, no instruction.
No instruction. The appeal is dismissed.
Item number 18.
Your Lordship's no instruction.
No instructions. The appeal is dismissed.
Item number 19.
May I please, Lord? The petitioner is challenging the order of the Honorable Single Judge, my lord, which has allowed the payment of retirement benefits to the respondent number 1, my lord.
Right.
There was a audit recovery from him, my lord. Around 3 lakh some odd amount was supposed to be paid as per the audit report. And learned single judge has allowed this writ applications only on the ground that there is an inordinate delay by the authorities in doing this audit, as well as may I place that also?
All permissions granted, sir.
My lord.
All permissions granted. Please argue the matter now.
My lord, the court has considered the rival submissions of the parties, gone through the record. Admittedly, the director agricultural marketing. I am reading page 11, my lord.
Yes.
The court has considered the rival submissions of the parties, gone through the record. Admittedly, the director of agriculture and marketing, Bhubaneswar, directed for special audit in year 2004. Therefore, the audit report submitted earlier in the year 97 has lost its sanctity for implementation. Therefore, the finding of inquiry officer and the recommendation to form a committee to consider the recoverable amount on the basis of the audit report of the year 1997 in a disciplinary proceeding has also lost its force in view of the fact that audit was not conducted in accordance with the procedure after taking into consideration all the material facts and relevant records available. Since the audit report submitted in the year 1997 has lost its force, the authorities should not have proceeded with the disciplinary proceeding on the basis of the said audit report. The petitioner has already received 50% of his retirement benefits. So the order was passed for, it's not retirement benefits, 50% of his gratuity he has received pursuant to the orders of earlier writ application, which he has filed. Though the order was passed for a special audit in the year 2004, the authority has not taken any step till date for such special audit. In the meantime, 9 years have elapsed and withholding the pension.
What is your answer to this?
There is pension amount. He is to get only the retirement benefits. It's
What
not-
is your answer to this 9 years delay?
Disciplinary proceeding was initiated, my lord. There was a recommendation for special audit, and only after the direction of the director Ostrom, this special audit was held, and it took some time, my lord.
What is sometimes, sir? 9 years. And even after 9 years, the inquiry is not completed.
And moreover, 3 lakh some odd was, and pursuant to the direction of this honorable court in this writ appeal, we have also paid another 34,000 some odd.
That proof is not there. The
No, I
noting
have got the instruction today. But check, he has received it. Lord, may kindly. Check number 132589 on dated 22/9/2014. 34,000 I have got. I can supply. I got it on WhatsApp. I can give it to the honorable court if your lordship may grant me some time.
No need,
Today-
sir. First, you satisfy us why we should entertain this appeal at all.
Because there were 3 lakh some odd. It's a small RNC, my lord. 3 lakh and some odd was. Many employees have paid pursuant to the direction of that audit. I have annexed those receipts, my lord. Other employees, but he did not pay it.
That's all right.
3 lakh some for 3,14,000 some odd was recoverable from him, my lord. I have annexed it, annexer 3 series, my lord, page 19 to 23, wherein it has been shown what is recoverable from him, my lord.
the Secretary Regulated Market Committee has filed his appeal against an order dated 7th March 2013 passed by the Honorable Single Judge, allowing writ petition civil 16075 of 2009 filed by the respondent. Number 1. Challenging the action of the appellant in not disbursing his retirement benefits after retirement from his post of yardman on 31st October 2008. Paragraph. The background facts are that the respondent one was working as a yardman in the Regulated Market Committee, Dungirapalli, in the district of Sonpur, bracket the present appellant, bracket. An audit was conducted in 1995-96, and an audit report was submitted on 19 December 1997. Full stop. It was mentioned in the report that on account of the non-submission of documents and non-cooperation of the secretary of the RMC, the audit could not materialize. Full stop. Paragraph. On the basis of the said report, the present appellant filed GR case number 46 of 1996 under section 409 IPC. The case was investigated. A final report was submitted by the investigating officer, finding no case against the respondent 1. Paragraph. The JMFC Rampur suo motu issued notice to the informant to file a protest petition. To stop that, order of the JMFC was quashed by this court by an order dated 19 March 2008 in criminal MC number 3243 of 2002. Full stop. Paragraph. While the criminal matter was pending, the present appellant started taking steps for recovery of the alleged amount. To stop. Challenging that, writ petition civil 358 of 2003 was filed by the respondent 1. To stop.
358 was filed by one Gaurang Charan Das Maharaj.
Sorry?
Not by 358 was filed by another person, Gaurang Charan Das Maharaj.
I see.
It was not filed by this respondent.
All right. It was filed by the one Gaurang Charan Das, which was disposed of on 11th February 2003 with the direction that no recovery would be made from the salary of the present respondent 1 till completion of the departmental proceeding.
Not from. It was from that respondent.
From the said petitioner. All right. The said petitioner. Paragraph. A direction was issued in a separate writ petition civil 6874 of 2004.
That was also filed by Gaurang Charan Das. Not
in
by
which
this.
an order was passed seeking inter alia a prayer for special audit. Ultimately, the special audit was ordered only on 11/10/2004. Paragraph. By the time of filing of the writ petition by respondent 1 in this court in 2013, the special audit has still not been conducted. Full stop. Respondent 1 retired on 31st October 2008 itself. Full stop. Initially, he filed writ petition civil 3763 of 2009, seeking disbursement of his retirement benefits. Paragraph. The said writ petition was disposed of by the learned single judge on 19th March 2009, directing the present appellant to release 50% of the gratuity amount payable to respondent 1, since he was a senior citizen by then. As far as the remaining amount is concerned, it was directed to be considered for disposal after disposal of writ petition civil 6874 of 2004. Meanwhile, the said writ petition became infructuous.
Dismissed as withdrawn.
Full stop.
was
As a
withdrawn.
result,
The state,
respondent 1 filed writ petition civil 16075 of 2009, seeking the reliefs mentioned herein before. Paragraph. According to the present appellant, a sum of rupees 314,893.70 had to be recovered from the respondent 1. A committee constituted by the appellant recommended the recovery of the aforementioned sum. From the respondent 1. Full stop. The learned single judge noted that the earlier audit report submitted in 1987 had lost its sanctity since the director, Agriculture Marketing, Bhubaneswar, had anyway directed for a special audit in 2004. Full stop. The question of, therefore, effecting a recovery against respondent 1 on the basis of the earlier audit report did not arise. Full stop. As far as the special audit was concerned, it had not been completed even for a period of over 9 years till the filing of the writ petition. Full stop. In this circumstance, the learned single judge came to the conclusion that the inordinate delay had made it unreasonable to deprive the respondent 1 from retirement benefits. Full stop. Paragraph. Even before this court, full stop. Accordingly, it was directed to be released to respondent 1 within 3 months. Paragraph. It must be noted that in the present appeal, pursuant to an order dated 5th February 2014, the balance amount was directed to be paid. The entire amount due to the respondent 1 was directed to be paid, except the amount which had been recommended to be recovered. Full stop. The appellant was directed to give an opportunity of hearing to respondent 1 and take a decision in the matter. Full stop. Did you do that, sir?
yeah, I had filed a further affidavit, my lord. Affidavit dated 17/8/2014, my lord.
Where is that?
I have a copy.
Annexure A, is it? Pursuant thereto, an affidavit has been filed on 17 August 2014, enclosing a copy of the order dated 6th May 2014, whereby the appellant rejected the claim of respondent 1. According to the appellant, even after adjustment of the retirement dues, Respondent number 1 further liable to pay rupees 167,856.70 to the regulated market committee. Who's appearing for the other side? The court has heard learned counsel for the appellant and has perused the impugned order of the learned single judge.
May I? On 10/9/2004, Lordship may kindly note that Lordship is directed for payment of this 34,000 some odd towards
Correct. You say the
gratuity.
balance amount, before that you say the balance amount of rupees 34,817,327
My lord. On
by way of gratuity has already been paid to the respondent.
on
Number 1. Paragraph. Having heard learned counsel for the appellant, court is not persuaded that the learned single judge has committed any error in directing release of the retirement dues of the respondent number 1 by the present appellant. Full stop. The facts of the case narrated above clearly indicate that for a period of over 9 years, no action whatsoever was taken by the appellant to conduct a special audit. Full stop. Meanwhile, respondent number 1 superannuated, and he was made to suffer on account of denial of his retirement benefits because of the indecision of the appellant. Full stop. There is no justifiable explanation offered for the inordinate delay in the appellant taking action in conducting a special audit. Full stop. In the circumstances, the learned single judge was perfectly justified in holding that respondent number 1 cannot be made to suffer for the lapses on part of the appellant in not even conducting a special audit prior to recovering an amount from the retirement benefits of the alleged due amount from the retirement benefits of the respondent number 1. Paragraph. Consequently, the court is not persuaded to interfere with the impugned order of the single judge. The appeal is dismissed.
Item number 20.
Say the payment will be made within 1 month, my lord.
Whatever is amounts are still due to the respondent number 1 should be disbursed to him
After deducting the
within a
already
period of
paid-
8 weeks. Full stop.
after deducting the already paid gratuity amount.
Anyway, that's all up to you, sir. No.
Item number 20.
In item 20, with your lordship's kind permission, I am appearing for the workman respondent. I have a preliminary objection in this.
1 minute, sir. Who's for the appellant?
My learned friend, Mr. Tripathi, is for the appellant.
Where is he?
He is there on the online. I think he is muted.
Ah.
I am raising a preliminary objection with regard to the maintainability of the appeal, which your lordship has been pleased to decide also recently. That is the order passed.
Yeah, 227. Correct.
Exactly, much obliged, your lordship.
Correct.
592 of 2011, disposed of on 4/5/2022. Your lordship has been pleased to hold the order having been passed in 227 not maintainable.
Correct.
However, this will not prevent the appellant from seeking any other appropriate remedies available in accordance.
Correct. Yes, Mr. Tripathi.
Yes, my lord. My lord, my reply to this, my lord, 2017 Supreme Court is very clear on that, my lord. The intra-appeal is not permissible, my lord. This is not an intra-appeal, my lord. But intra-appeal means like in Workmen Compensation Act, EC Act, my lord, the appellate authority is Honorable High Court, my lord. Section 30, they have to prefer.
No, the impugned order is by a single judge of this court or not?
Yes, my lord.
Then it is an intra-appeal.
This is a, my lord, certiorari proceeding, my lord.
No.
So my lord's appeal lies to Supreme Court only. This is not appellate authority, my lord. The High Court sitting in a certiorari proceeding, it's not appellate authority. The appellate authority is 136 Supreme Court, my lord. Your lordship just passed.
It's not about appellate authority, sir.
Yes,
You've challenged an order of the labor court, right?
Yes.
A writ petition challenging an order of the labor court.
Yes.
Is a writ petition under 227, against which no appeal lies. Yes. So the appeal is not maintainable, sir.
My lord, let me clarify this. 2017 Supreme Court, my lord. Just give me a moment, my lord. I have to, because these points were never raised. So let me take out the decision, my lord.
We'll pass it over. You pick up the decision. Pass over.
Item number 21.
My lord, the property involved in the present writ appeal, that has already been decided in favor of the DT. I am for the DT appellant, my lord. So it has lost its relevance.
All right. The appellant states that due to subsequent developments, the appeal has been rendered infructuous.
Refer to the order. That is WPC 14813 of 2009, decided on 18/1/2018. That may be referred because otherwise they will.
It's all right. You can explain to them. Sir. Yes.
Item number 22.
None appears dismissed on non-prosecution.
Item number 23.
None appears dismissed on non-prosecution.
Item number 24.
None appears dismissed on non-prosecution.
Item number 25.
None appears dismissed on non-prosecution.
Item number 26.
None appears dismissed on non-prosecution.
Item number 27.
27, my lord, not maintainable.
Not maintainable. All right.
My lord, because that 227.
No, you're for the opposite party or for the appellant?
It is no, appellant.
Okay.
There's a arising out of civil suit.
Yeah. This is a matter arising out of a civil suit. No, the writ petition civil 6781 of 2012, which was decided by the impugned order, arose out of a civil suit. Consequently, the present appeal is not maintainable and it's disposed of as such.
Item number 28.
28 became infructuous.
Consequently, the appellant states that the appeal has been rendered infructuous. It is disposed of as such.
Item number 29.
May I please, Your Lordship?
Yes.
This is the Anganwadi matter.
Yes.
The appellant is for Lordship challenging the order passed by the Honorable Single Judge under Annexure 1.
Yes.
Here the point is, my Lordship, point is very short. Here
Yes.
the appellant along with three others applied for the post of Anganwadi.
Yes.
And the application was full and complete.
Right.
And on the day of scrutiny, as per the instructions, the candidates were to be remain present. And so far the present appellant is concerned, she was ill and she filed a time petition, Annexure 5 to my present appeal. Your Lordship can see on the ground of illness.
Right.
That she is ill and that is why the time may be extended to remain present for scrutiny of the application, which was in complete form. Your Lordship can see page 28.
Yes.
It is in vernacular blood. They applied for time. Time was allowed, along with another candidate also, who was also absent. And accordingly, after that time which was allowed, that was not challenged by anybody, including the respondent, the aggrieved respondent. Then the matter was decided on merit. The appellant secured the highest marks. She was appointed as Anganwadi worker. Then she preferred appeal before the sub-collector. Sub-collector allowed it. I approached this Honorable Court in a writ petition. WPC 15820 of 2008. And this Honorable Court directed me to file the appeal before the collector. And accordingly, I filed the appeal before the collector. And the collector allowed my appeal. And challenging that, the aggrieved respondent, he preferred the writ petition before this Honorable Court. And this Honorable Court, while deciding the matter in a lengthy judgment annexure 1, that is from page, relevant page from 9 onwards, that the authority could not have extended the time to remain present for scrutiny. And accordingly reversed the order of the collector.
Yes.
So the point is that there is no statutory law. Only executive instructions were there. And my applications were full. And on the day of scrutiny, I filed an application which was allowed. And that was that the application was not challenged by anybody, any of the candidate. And having done that, whether that extension of time is valid, can be held to be valid, particularly the purpose of selecting is the best candidate among the all applicants.
Yes.
And I was the best candidate among the all applicants. And on the ground that on the finding that the authority could not have extended the time for scrutiny,
yes,
it reversed the order passed by the collector.
Correct.
So whether the extension of time can be held to be valid so far to achieve the object.
There is a deadline, sir, within which we have to do things.
My lord.
You can't simply be granted an extension of time. These are all
Right.
selection matters.
Yes, selection matter, but it's not a codified law. It
But
was
still, you can't have arbitrarily one candidate being given extended time.
no. Everything was adjourned. Not that one credit was done.
Yes.
The scrutiny date was adjourned. That was not challenged.
Yes.
The extension of time granted to me was not challenged.
No, can't be a separate intermediate challenge, sir. Only when you don't get selected, you will challenge. Yes.
That is the short point to be decided by law.
Correct. We're not inclined to interfere, so we'll pass the detailed order.
My lord.
All right. Writ appeal dismissed. All right.
Item number 30.
Your Lordship, appearing for respondent, there is no instruction in this matter.
Respondent.
Yes,
None appears for the appellant. Dismissed.
Item number 31.
May I please, Your Lordship? I mean BC, ma'am.
Yes.
Here challenging an order under section 14 of the Arbitration and Conciliation Act, terminating the mandate of the arbitrator. I have approached the Honorable Single Judge, and the Honorable Single Judge has dismissed the writ petition, saying that you have an alternative remedy under section 115 of CPC.
Correct.
Now, in the meantime, my lord, some of the arbitrators have expired,
Yes.
and new arbitration tribunal have been constituted.
So nothing survives in this, sir. Due to subsequent developments, the present writ appeal has become infructuous and is disposed of as such.
Item number 32.
None appears dismissed or possible.
Item number 33.
Item become infructuous. Item 32. Item 32.
Counsel, the appellant states the appeal has been rendered infructuous. It is disposed of as such.
Item number 33.
33 has become infructuous, my lord.
Infructuous, disposed of.
Item number 34.
34 is a PI hearing.
None appears dismissed or possible.
We are for the railway, my lord, or appearance noted.
Item number 35.
35, the matter is infructuous.
Infructuous, dismissed.
No, we are appearing
Item number 36.
None appears dismissed or possible.
Item number 37.
PK appearing for the opposite party.
All right.
CGC.
None appears dismissed or possible.
Item number 38.
Yes, my lord. My lord, this matter already infructuate.
All right. Infructuous, dismissed.
I am for the respondent, my lord.
Yes.
Item number 39.
None appears dismissed or possible.
Item number 40.
None appears dismissed or possible.
Item number 41.
My lord, item 39, I was there.
Yes, tell us.
My lord.
Tell us, sir.
My lord, item 39, this is regarding illegal shifting of office of block education office from one place to another or simply on political ground, lord.
No. These are not matters of public interest. I'm sorry.
No, this affects the public interest.
No. We're not interfering, sir. These kind of matters, we are not interfering at all. The mere fact that a block office.
No, this is in violation of the guidelines, lord. Government's own guidelines.
There is no cause of action is survive because they are challenging shifting, but now the shifting has been
long ago.
Building it is the counter.
Correct. You see, the writ petition itself filed in 2014 challenged the shifting of the office of the block education officer, Juamora, from Hatibadi to the block office premises of Juamora. Full stop. Apart from the fact that these are not matters for the court to interfere under Article 226 of the Constitution, it is seen that there is no interim order passed in the writ petition, and the shifting is already taking place long ago. For these reasons, the court is not inclined to interfere. The writ petition is dismissed.
Item number 41.
None appears dismissed or prosecution.
Item number 42.
None
I am
appears.
appearing for railway opposite party members.
All right.
Sanjeev Swain.
Yes.
I am appearing for opposite part number 5, my lord.
All right.
Sanjeev Swain for railway.
Item number 43.
None appears dismissed or prosecution.
Item number 44.
None appears dismissed or prosecution.
Item number 45.
If I have no instruction.
No instructions dismissed.
Item number 46.
None appears dismissed. No possible.
Item number 47.
Appearing on behalf of respondent.
May please your lordship. I am appearing for the petitioner, my lord. This is a PIL matter. Matter relates to supply of pollution-free drinking water to the people of Odisha, my lord. Notice has been issued. Counter and rejoinder has been filed by the respective party. I would like to draw your lordship kind attention to order number 40 dated 19/8/2019, my lord. I would like to place this said order if your lordship permits.
Yes, yes, permitted.
My lord.
I am appearing.
Hard, the matter requires consideration, admit, and the read petition to be shown on hearing board. The members who are the head of the department nominated by Mr. Mahanti, chairman of monitoring committee, constituted pursuant to the order of this court dated 22nd July 2019 cannot be accepted. If he wants to proceed with the matter, he can approach the persons who are experts in the subject matter of the writ. Accordingly, my lord, we have already nominated 3 persons, and accordingly I have filed a interim application which is registered as 7039 of 2022, my lord. Question, issue, my lord, cause of action arises, issue survives. I would like to place some of the paper clips of the news item wherein it has been reported that for a drop of drinking water, a woman is climbing 25 feet mountain, my lord, in Keonjhar, my lord. In Cuttack city also, the people and inhabitants are not getting drinking water regularly, my lord. I would like to place the paper clips of the news item if your lordship permits, my lord. So the cause of action arises and issue
Not
survives.
paper clips, so you have to file an affidavit.
My lord,
Then you can reply.
My lord, I will file an affidavit, my lord.
May I submit, my lord?
Yes.
My lord, this issue, my lord, is already sized off in writ petition number 2746 of 16.
Okay.
My lord, to recollect, Watco had filed an affidavit as to phase-wise implementation.
When is that coming up?
My lord, that is on 10th October.
All right. List on 10th October along with 2746.
2746 of 2020.
2000 and?
Sorry, 16. 2746 of 16.
2746 of 2016. In the meanwhile, the petitioner is permitted to file an affidavit with an advance copy to Mr. Nayak, learned counsel for the CMC.
My lord.
Right.
Oblige, my lord.
Item number 48.
I may pardon, my lord. Item 46, my lord, just to leave the association.
Yes.
The advocate died, the person, mother and father also died. For that reason, he is sometimes not in mental condition. Just to Monday, you will
No. Why keep all this pending, sir? No need to keep it pending, sir. Right. Yes.
Item number 48.
Your lordship.
You already passed the order, sir. No need to keep it pending. Yes.
My lord, item 48, I'm appearing on behalf of Mr. Rai. My lord, Mr. Rai is on his legs in another court.
Pass over. All right.
Item 49.
None appears dismissed. No possible.
Item number 50.
In this case, my lords, I'm appearing for the petitioner, my lord.
Yes.
This case is for illegal slaughter of cow and the illegal transportation of cows to neighboring states, my lord.
Yes.
My lord, I believe that as far as transportation is concerned, my lords, I think your lordship has directed another matter in July 22. So I come back to the other micro issue, my lords, about illegal slaughter happening in our very own city.
Yes.
At Cuttack.
Yes.
So in this case, my lord, the opposite parties have filed counter, not all of them, but most of them are referring to the fact that it's under CMC, my lords. And CMC till date has not filed a counter.
So Nayak was here.
CMC,
Nayak was here just now.
It can appear at CMC. It will give copy.
Copy of the petition to the court.
Copy of the petition be served on counsel for the CMC today itself. Reply, if any, by the CMC be filed within 8 weeks. Rejoined for the next date list on 14 December. Yes.
Let a copy please.
Right.
Item number 51.
Mail, please. And in this case, the opposite party is given they have filed the counter, but that copy has not been served to me. But the case is that Miller, for construction of the Kalyana Mandap Miller, they have initially fixed you on a plot Miller. And thereafter, after election Miller, another Sarpanch came and he chose another place Miller. For which Miller, the petitions gave the representation to the collector and also the other persons Miller, the widow, that the Kalyana Mandap should be constructed in the middle of the village Miller. And that's why the notice has been issued to the opposite parties and they have given the...
How is all this public interest, sir? These are not matters for public interest litigation, where Kalyana Mandap should be in the middle of the village or outside the village.
It is well within the particular area. This place or that place.
The location of a Kalyana Mandap in the village cannot be the matter of a public interest litigation.
But it is in the middle of the village, that should be constructed, that established.
No.
Otherwise,
these are not matters the court would like to interfere.
And the counter have not given the counter
to Article 296 of the Constitution. The writ petition is dismissed. Yes.
Item number 52. Fresh admission.
With the liberty to approach the appropriate
no.
authority.
It's all right.
Item number 52. Fresh admission.
Yes.
May I please, Your Lords?
Yes.
The appellants are convicted for life.
All right. Admit the LCR be requisitioned. Paper books be prepared and supplied to counsel for the parties to be included in the list of final hearing thereafter. In this application for realization of fine stay during the pendency of the present appeal, the IA is disposed of. How long have they been in, sir?
They are in custody from the date of judgment, that is 4/2/2022. Earlier they were on bail.
Don't press it now. 485/2022. Counsel for the appellant does not press this application at the present stage.
Let it lie over mail.
It's all right. File a fresh one. That's better. Yes.
Okay.
Item number 53.
May I please, my lords? The appellants have been convicted under section 490-302.
Yeah. You said admit that fine amount to stay during the pendency of the present appeal. How long have they been in? Oh, there's no other IA. All right.
My lords,
LCRs be called for. The paperwork be prepared and supplied to parties, counsel the parties within 8 weeks to be listed in the to be included in the list of final hearing matters thereafter.
Great.
Item number 54.
Item number 54, the appellant is convicted for life imprisonment.
No, admit that fine amount is stayed that IA is disposed of. Bail, how long has he been in?
Lords, he is in no instrument. Bail is custody since the judgment 15/3/2022.
All right, not pressed at this stage. Disposed of. Right.
Item number 55.
None appears dismissed in normal session.
Item number 56.
But it was dismissed for default. He escaped from the list.
All right. The reason stated, the application is recalled. The order is recalled. The application is allowed. What's the main matter about, sir?
Main matter is the public interest litigation. That normally, your lordship knows the coastal area, coastal district, Puri, Khorda, Ganjam, all these Bareswar, they are very cyclone prone. And those people, they depend on the fishing, all these things. They don't have agricultural land. So that is why 3 cyclones totally devastated. And for other district, that was completed, providing houses, cyclone protected. So for this Puri district, this is 2 blocks. One is Krishna Prasad, another is Brahmagiri. For that, 3,047 beneficiaries, and those who are to be provided the houses under the scheme. And that your lordships in order dated 19/4/2021, lordship kindly see. In that order, the lordship had taken cognizance of these things and directed that, my lord, that is from the Osdama through the World Bank, the government was providing money at the rate of 3 lakhs per houses. And that was, they were identified and given. And the installment, 5 installment. And they had approached your lordship at the juncture, while after disbursing 3 installment, 2 installment and further installment not given. And that is why they had come. For them, this petition had been filed. So your lordship directed, and apart from that also, those who are landless, totally also houseless, they don't have anything. That is why there is a provisions as per the scheme under Annexure 2, they will be also provided land and houses.
So you kept taking time for some rejoinder. You never filed the rejoinder.
Rejoinder we have filed, but your lordship.
When did you file?
That we have filed, your lordship taken note of that. That is 6/1/2022.
No. 1/11/2021. We have said rejoinder be filed before the next date.
Well, on 6/1/2022, rejoinder.
All right. The writ petition is now.
And one thing I beg to draw your lordship's attention, that your lordship's order, this order has not been, apparently the affidavit file has not been exercised, no exercise has been done. Because
you have to conduct an inquiry.
That your lordship may list it before the roster bench.
Yeah, list before the roster bench. That is this bench only, sir.
But is your lordship's bench?
List on 22nd November. In the meanwhile, compliance be effected of the order. Meanwhile, the opposite party states will comply with the order dated 19th April 2021 and file a compliance affidavit.
Let's say posting the matter to that.
22nd November.
Obliged.
Item number 57, fresh admission PIL.
May I lordship, please? My lord, I am in the VC, my lord.
Yes.
My lord, the petition is the worshipper of Buddha Ganesh and is the chairman and president of Buddha Ganesh Puja Committee, my lord. This, my lord, kindly turn to Annexure 2, page 15, my lord. This honorable court passed order, my lord, kindly comes to the last, just before to the last paragraph. Got it, my lord? Page 15, my lord, Annexure 2.
Yes. What is the date of this order?
Date of this order is 16/9/2015, my lord.
15. Okay.
Yes,
Wrongly put as 22.
My lord, it is suggested that the procession for immersion of Ganesh idol can be permitted on 3 successive Sundays after the date of Ganesh Puja and the place of such immersion of Ganesh.
Anyway, you made a representation. Let them consider your representation.
My lord, your lordship, I have filed the instruction. What has happened? By order of this honorable court, 3 dates have to be fixed for immersion of Ganesh Puja. That is 3 successive Sundays. And this year, the last Sunday is coming on Dutiya Asa, which is a festival of Ye. So the representation was made by the petitioner to shift that to any other date. So now I have given that 18th to 25. But there is a clear-cut direction of this honorable court. Your lordship may kindly have the second page of that order. No procession for immersion of Ganesh idols shall be permitted on any other days.
That is for that year, sir. This is not for all times to come. This is for that particular year.
Following. So unless this order
this order is only for that year, sir. Please.
Yes, ma'am.
Your lordship may clarify.
It's clarified that the order passed by this court on 16th September 2015 was obviously for that particular year of performance of Ganesh Puja. It was not meant to apply for all times to come. It will be open to the district administration to vary the dates of permission of immersion of the Ganesh idols.
From 18th to 25th.
From 18th to 25th of September 2020. The petition is disposed of. Right.
Oblige, my lord.
Item number 58.
Wait, please, your lordship. My lord, in 58, it has come for correction of a typographical error.
Or the order is corrected.
Only,
as indicated.
Your lordship, may I pray a small prayer, your lordship? Since I have not pressed it, it has been disposed of.
Yes.
If your lordship will only observe one line kindly, that my security amount they may return as they calculate. That will serve. A poor man will be saved, your lordship, by only one line observation of this honorable court.
I don't know about that, sir. Today it's come only for this. No.
My lord, I have deposited the amount, challenged it.
No. This is because the registry has pointed out a typographical error. That's all. Let's not add to this. No, this today is not for any passing orders now.
Okay, your lordship will only observe that the security amount.
No. Sorry, sir. Sorry.
Item number 59.
May I please, your lordship?
Yes, lordship's direction,
the husband respondent is now handing over 1 lakh money that is towards permanent settlement amount 5 lakhs. So out of 5 lakhs, I was to pay last 1 lakh. Now that amount is now being given. It may other side.
Your Lordship,
Yes,
Your Lordship,
yes.
kindly have a glance to order dated 11/7/2022. In para 3, I state that the balance amount is paid. It will not settle all the claims. Let him pay that 1 lakh. My associate is there. And Your Lordship may.
Where is your associate?
My Lord, Gayadhar Samal is there. My associate is
All
there.
right. You say 1 lakh has been handed over in court today by way of a demand draft by the respondent to the appellant's counsel, which has been accepted.
And let it be come in another date in month of November for hearing, for final
All right.
hearing.
List on 24th November for final hearing. All right.
Yes, ma'am.
All right. All right.
Item number 60.
It become infructuous also.
Counsel, the petitioner states the petition has been rendered infructuous. It is disposed of as such.
Item number 61.
My Lord, there are some defects pointed out. I may permitted to verify those defects.
All right. Defects will be removed in a
I'll,
week. List thereafter. All right.
My Lord,
Item number
may have
62.
taken up a week after. I'm in personal difficulty in the next week.
Whatever, sir, it will come up there. Okay.
Item number 62 for orders, PIL.
None appears dismissed for non-prescription.
For the appearance of 61.
No, some IA for withdrawal with writ appeal. All right. This IA 2864 of 2022.
May I please, Your Lords? On behalf of Sri Bimbisar Das, Senior Panel Counsel, Government of India, my Lord, his presence may be noted for Union of India, my Lord.
Oh. All right. 2864. This is already disposed of. Oh, not already disposed of. All right. The IA is allowed. The writ appeal is disposed of as not pressed, as prayed for. Right.
Item number 63.
May I please, Your Lordship? I am on VC due to fracture my leg. My Lord,
Yes.
the petitioners are in possession of the aforesaid land more than 30 years. The government has making a colony, settled them in the said land. But one, Manoj Kumar Mishra earlier filed a writ petition before the Honorable High Court. Honorable High Court directed the collector to dispose of their representation. The collector, without giving notice and without giving personal hearing, disposed of the same, passing order for eviction. In respect of the same, I have filed a review petition before the collector. At the same time, I, before Your Lordship, kindly issue notice and made them here in what basis the order has been passed, because they have been settled by the government and they are in possession by making a colony there.
But this is a 2020 petition, not been listed once, sir.
My Lord, we are on the land, my Lord, and by way of constructing the land, and that is money is spent by the government also, my Lord.
Sorry?
Government constructed a colony and settling the petitioners, my Lord. Collector, not aware of the fact, without giving opportunity to the petitioner, passed order of eviction.
But that eviction order is not obviously carried out because you are very much there.
My Lord, because we are in possession and we are settled by the government, Consider has not evicted us. So it is under consideration of
My
the
Lord,
collector.
these are all
Review
government
petition.
lands. Rakhit Khadda. They were in an unauthorized occupation. If any eviction order has been passed by the Tahsildar, then they can approach the sub-collector in appeal.
I see.
Because
against the impugned order dated
My Lord, because direction
21st
was
March
to the collector, my
2020,
Lord.
the appellants, the petitioners apparently have a remedy by way of an appeal before the sub-collector.
Yes, ma'am.
My Lord, for a minute, my Lord, collector has passed the eviction order on the basis of the order passed by the Honorable High Court, my Lord. On the basis of the writ petition filed by Manoj Kumar C.
Who collector has passed the order.
My Lord. Without giving us opportunity of hearing, because we are in possession that too government has constructed that colony and settling us more than 30 years.
Collector.
The impugned orders by the collector.
Yes, annexure 1.
So he can't file a further review.
My Lord. We have also filed a review.
I'll file counter.
All right. You just say notice, Mr. Mahanti accepts notice on behalf of opposite party numbers. What is this opposite party number 4? Why is a private party?
Private, he has filed the writ petition for eviction of the petitioners.
Oh, at his instance, the PI was filed and your lordship directed the
I see.
collector.
Notice will issue to respond before opposite party number 4 by registered speed post returnable on the next date. Replies be filed within 4 weeks of service of notice. Rejoined for the next date. List on 5th December.
Item number 64.
Permanent to withdraw, my lord.
Counsel to petition seeks leave to withdraw this petition. Dismisses withdrawn.
Item number 65.
None appears dismissal, non prosecution.
Item number 66.
None appears dismissal, non prosecution.
Item number 67.
67, I may please permit it. Item number 67, my lord. It's
Mr.
public.
Das, you have to serve a copy of the.
I have already served. Here I have the receipt. I have already.
Yes,
On
Mr. Das.
20, on 4/8/2022.
All right, he's there. He's there.
This is second successive writ application, same point, my lord. One writ application, WPC PIL 5732 of 2022 is pending, and we have filed counter in that case.
No, your lordship was before this honorable the before two writ petition was filed, and your lordship had disposed by giving liberty to the petition to make a fresh application.
No, there is another petition, madam.
732 by 2022 is pending. Your lordship has fixed it to 22nd November, my lord.
All right, list on 22nd November.
May I submit?
Along with writ petition civil 5732.
Petition PIL 5732 of 2022.
5732 of 2020.
May I submit online, my lord? May I be permitted? Your lordship considered that he losing of innocent life. So before this, can it be listed before this 22nd November, my lord?
There's already another matter. There's already another matter on the same issue.
May I know the number?
I've just dictated it, madam. He's repeated it twice. I've dictated in the order. Please get a copy of the order and you'll get to know the number. Yes.
Okay.
Item number 68 for orders.
Yeah, please. There is a 100-day delay.
Delay unexplained. The delay is therefore not condoned. Consequently, the appeal is dismissed. This contempt petition, you say the impugned order now be implemented. Without delay.
Partly complied with.
It's all right. Be complied with without delay. The application contempt petition is disposed of. Right.
Item number 69.
69, my lord. In this case, I have filed in caveat, my lord.
No, 1 minute. Let them first tell us.
Let's turn to page 46, annexure 1. The impugned order is at page 48, my lord.
Yes.
That honorable single judge relying on one order passed in 16906 of 2020 had disposed of this writ petition. That order has been stayed by my lords. In W number 127 of 2022.
Notice he accepts notice on behalf of respondent number
1.
1, 2, and 3.
1, 2, and 3. When is it listed, sir?
On 1st November.
List on 1st November, along with WA 127 of 2022. Till then, the impugned order shall remain stayed. Right.
Item number 70.
Let's turn to page 16, impugned order. It starts at
IA for dispensing with certificate copy that is allowed. Delay is also not COVID.
Yes, my lord. During the
COVID periods, that is also allowed and disposed of.
And the impugned order is at page 17. That pointed that during pendency of the criminal case, from direction has been issued.
For notice. When are those matters coming up?
On 28th October.
List on 28th October. Notice additionally be served on counsel appeared for the writ petitioner before the learned single judge. till the next date, the impugned order shall remain stayed.
Item number 71.
Your Lordship, turn to page 10.
Here again, the IA for dispensing with is allowed, IA for continuation of delay is allowed.
Your Lord, Your Lordship, I have given the order, similar order, Your Lordship has fixed it to 21st November 2022.
Same order.
Your Lordship, I have given, I am for the respondent number 1. I have
He
given
accepts notice for respondent number 1.
Madam. Series of cases, Your Lordship, where Honorable Supreme Court has confirmed the order of this court, and now they are getting implemented and getting pension. For that reason, on my memo, Your Lordship, this has been listed.
21st. 20th July.
Yes.
Item number 72.
May I please listen? There are some defects, my lord.
Yes. Defects be cured within a week, list thereafter.
This has come on my mention. May I pray a shorter date? I didn't know.
1 week. So you cure it within 1 week, will be listed soon thereafter. Right.
May I pray for a date?
All right. List on, or you say list on 21st September, defects be cured by then.
Item number 73 for orders, criminal appeals.
May I please, Your Lordship, this is an IA filed by the present petitioner for bail, Your Lordship. The petitioner is inside the custody since 31/8/2013. He has convicted under section 302, 304B, 498.
Want to take instructions?
I'll take instruction.
All right. IA number 69 of 2022, notice, she accepts notice and seeks time for instructions. List on 21st September.
In this paper book, but is already ready.
Right.
Item number 74.
Application for interim bail for the marriage of the sister of the appellant.
Your
Lordship.
What's your instruction?
Yes, we will receive instruction from the IAC Bisoi PS, my lord, that indeed he's the only son and his sister's marriage is on 16/9/2022.
All right. The counsel for the learned additional government advocate confirms that the applicant's sister's marriage is fixed on 16 September 2022 and he's the only son. In that view of the matter, the application is disposed of by directing that the applicant oblique appellant shall be released on interim bail for a period of 2 weeks, the date of his release, subject to terms that may be fixed by the trial court. That will be fixed by the trial court. The surrender certificate is placed on record immediately upon the expiry of the interim bail period. The application is disposed of. This is IA 1358, correct? Of 2022. Yes.
Item number 75.
Number 75, I may be pardoned for appearing through DC, my lord. I am suffering from fever. My lord,
Yes.
in the noting, a defect has been shown. I will verify the same and.
This appeal has not been admitted yet.
No, my lord. This appeal is by the informant.
Oh, I see.
Against the acquittal of the accused person.
Oh. So defect be cured within a week, list thereafter. All right.
Much obliged.
Item number 76.
Item number 76, madam, there are some defects in pointed out. I will rectify it by next week, my lord.
Removed in a week, list thereafter. All right.
Item number 77 for admission.
And a copy of the report of the Women Commission has not been served on me till date. It's related to the maternity date and my lord had directed an inquiry into that matter.
The registry is directed to serve a copy of the report of the National Commission for Women on counts of the petitioner forthwith.
My name may be reflected so that...
the name of Mr. Omkar Devdas be shown for the petitioner. List on. Give me the date of PIL chart. 27th October.
Item number 78.
My lord, pass over
All right,
Council lessons.
All right.
Yes, sir. I am in line. Not virtual, my lad.
Yes.
Well, Well, in fact, I couldn't reach because so much of traffic rush is difficult. But so I am in virtual.
All right.
Lordship may kindly see the order dated 6th of May 2022, 16th May, my lord.
Yes.
The main prayer in the petition is for a direction to the opposite parties to declare Salehpur as a notified area council.
Yes.
Mr. Muduli, a learned additional government advocate, states that although the earlier reply was filed way back in 2017, the current status may be permitted to file a. Well, thereafter, Lordship may kindly see the order number 8, my lord.
Yes, yes. Let me just ask them. Yes.
Yes.
Where is Mr. Mudali?
Yes, my lord, I am there.
Ah, you are there.
Yes.
An affidavit was to be filed, sir.
Well, affidavit has been filed, my lord.
No,
Affidavit has been filed.
some endorsement was made to the Panchayat Raj
Yes, my lord. Yes.
department.
That is on 19th July 2022.
The file had not been returned to the Housing and Urban Development Department. What's the current status? Mr. D.K. Manthil under AGS states some more time to apprise the court of the current status of the file. At his request list on
2 weeks maybe.
29 September.
Okay.
But it's only they say that it is only sent to the Panchayat Raj department, my lord. Panchayat Raj department has just to revert, my lord. There is nothing else, my lord, to be done in that, my lord.
All right.
Item number 79.
Next week, man.
Why next week? What's the matter about?
Ambika Prasad Rai on behalf, minus.
No, what is the matter about, sir? Pay and claims of the farmers of Polasara block.
They are supposed to file an affidavit as per order dated 11th March 2022.
The order dated 11th March 2022 has not been complied with yet. As a last opportunity, list on 20th October 2022.
Item number 80.
Item 80, I am appearing today at the agenda, my lord. I can stop the copy.
Item 8, my lord, item 80, we have already, the prayer has already been allowed, my lord. Your Lordship may turn to page 19 of my counter, annexure B by 5. On the last 3 occasions, my Lord has taken time to file rejoinder.
Today I am filing rejoinder, my lord.
Paragraph 5, your Lordship may see. In view of the above, as recommended by you and independent engineer of the subject stage, considering the VIP reference and public demand, as per policy number such and such, dated 21/12/2017 and 111.1.27 dated the competent authority has accorded in principle approval for construction of PUP in size such and such, slip road for 200 meters on either side, and RCC covered drain up at the either side at Pipilia Chowk, amounting to 13.46 crore under change of scope to the existing contractor for early execution of the work.
My humble submission, my lord.
Nothing survives.
They admitted our situation. What is the problem with the happening in the area? That is declared as a black spot road. That is in mentioned.
No, but they're taking these steps, sir.
They are for only for PUP, pedestrian underpass. But we are praying for freeways.
Sorry?
Freeways. We are praying for freeways, but they are only PUP. There is a small area on small underpass.
So what is your problem? You just want to go from one end to the other.
My lord. I mean, I'm mentioning my agenda. That is a problem. That the petition must submit that the construction of pedestrian underpass, that is a PUP, will not solve the problem of the local resident. Because in such underpass, the school bus, truck, tractor, and agriculture machines cannot move from side to side, one side to another. That is the problem.
No. I'm sure the tractors and all will not move. I think tractors will move.
Yes, ma'am.
Tractor, but not truck, I think. It's a small.
Truck, school bus.
School bus can move.
School bus can move. Trucks need not move, sir. School bus can move.
Attach the photograph of the local area.
No. When the underpass is constructed, he says bus can move.
That and also the B57.
Let him file that, my lord, Legender. I'll take instruction.
Okay.
Okay.
I'll start with Legender.
Yes. My associate is there.
No, but why should we keep this pending?
Yes, my lord. Because
it has been approved.
Your lordship may see the prayer. Your lordship may see the prayer number 1.
Yes.
Why the opposite will not take appropriate for construction of flyover bridge on national highway, as to why the opposite party shall not take immediate steps to make appropriate alternative arrangement till construction of flyover bridge. So only 2 prayer, but we have given a bypass road along with RCC covered then everything we have allowed, my lord. In addition to public underpass, my lord. Because, my lord, for public underpass, my lord, we have to construct a flyover, my lord.
Yes. In para 11 of the affidavit of NHAI, it is stated as under paragraph. Counsel for Mr. Das, learned counsel appearing for NHAI, clarifies that at the proposed, what is PUP stand? Underpass? What underpass? Sorry?
Pedestrian underpass.
Pedestrian underpass, bracket PUP, will be usable by motor vehicles, including tractors and even buses, but not trucks. Full stop. In the considered view of the court, the petitioners would do well now to follow up on the above proposal for its timely implementation in accordance with law. The petitioners, no further directions are called for at this stage. The petition is disposed of. Right.
Item number 81.
May I please, Your Lordship? My senior has some personal difficulties, so this matter may be shifted to the next week.
Counsel, the petitioner stated to be in some personal difficulty. List on 24th November.
Item number 82.
None appears to so normal question.
Item number 83.
Item 83, may I please hold my lord, since Mr. Katkia is on leave for a bereavement, my lord, I'll be submitting on his behalf. My lord, a sealed cover report has been given to your lord.
Has been given? All right. Open it. Let's keep it here. That's a note by LR. All right. The investigation is closed and now charge sheet has been filed.
Charge sheet against 3 persons, my lord.
Four.
Other 2 persons.
4 persons has been filed.
Other 1 person, police officer, has not been arrested, my lord.
He has submitted his report.
1 police officer has not been arrested.
You file your protest petition.
Yes, ma'am.
You can file your protest petition. You say the final report dated 5th September 2022 of the SP CID-CB Odisha states that a final charge sheet has been filed on 5th September 2022 under section 376 bracket D capital A, 376 2 bracket N, 506 read with 34 IPC, and section 6 of the POXO Act against 4 accused persons. Full stop. The investigation has been kept open. No. It is stated that according to, it is stated in the status report that no substantive evidence has surfaced to prove the involvement of any other accused persons, as alleged in the FIR. Paragraph should be open to the victim's family. It will be open to the victim's family to take appropriate proceedings in accordance with law. The petitioners, no further directions are called for. Right in the beginning, we say a final status report has been submitted in the seal cover, which has been opened and perused in court. Then in the end, you say the report be placed back in the seal cover. All the status reports filed in seal cover be placed under the custody of the Registrar Judicial and will not be allowed for inspection by anyone except under orders of the court. No further directions are called for. The petition is disposed of.
Both the petition.
Passover matters, item number 20. Item 20.
May I please Lordship Manus? I'm in virtual Manus. I'm in virtual mode Manus.
Yes.
Yes. Manus, this is 2017 5 SEC.
Yes.
533 Manus.
Yes.
May I please to submit this Manus?
Yes.
It's a very big decision, my lord. So operative part, my lord, that is 558, my lord.
Yes.
At this stage, it is extremely necessary to call out the conclusions which are deducible.
Keep it with the matter in which it was taken.
Yes, my lord. May I read, my lord?
2017 5 SEC?
2017, my lord, 5 SEC, base 533, my lord.
533?
Yes, my lord. The operative part I am going through, man, that is 558, my lord.
Yes.
That is 42, my lord. Para 42, my lord.
Yes.
At this stage, it's extremely necessary to call out the conclusions which are deducible from the aforesaid pronouncement. They are 41.1 minutes. The appeal shall lie from the judgment of a single judge to a division bench of High Court, if it is so permitted within the ambit and sweep of the letter patent, my lords. So, my lords, may I please to take your lordship to take a High Court rules, my lords.
Yes.
Yes, ma'am.
Orissa High Court rules.
That is clause 10 of High Court rules, my lords.
Yes.
And we do, you lordship got it?
You read it, sir.
Yes, ma'am. Yes, ma'am. And we do further order that the appeal shall lie to the said High Court of Judicature at Patna from the judgment. Then, my lords, not being a judgment passed in the exercise of appellate jurisdiction, my lords.
Right.
This is clear, my lords. So, in this case, my lords, the learned single judge also here not interfered saying that this is a society proceeding. I am not sitting in appeal, my lords. That is, my lord.
That clause 10 was not at the time of writ petition, sir. Clause 10 was not at the time of writ petition. Yes.
Sorry, my lord.
So this was not at the time. What you're reading, that was drafted at the time, and this was not envisaged. Yes. This is well settled, sir. If a writ petition is under 227, no writ appeal lies against that.
Your Lordship, in that case, Your Lordship may kindly have a glance to the judgment passed by the only single judge, my lords. The page 18, my lords.
Yes.
Yes, he has categorically stated that I am not sitting in appeal, so I cannot reappreciate it.
Not sitting in appeal, sir. Nobody is saying that he's discharging under 227 an appellate function. Who's saying that?
Yes, my lords.
It's not an appeal. Obviously, it is not an appeal.
Yes, my lord. So unless my lords it's a, unless my lords it's
No, that is not correctly reading the provision, sir.
Your Lordship, the page 18, my lords, of the judgment, running page 18, page 6, internal page 6 of the judgment, my lords. Now,
Yes, yes.
Yes, my lords.
Yes.
Because, may I read, my lords? This is 1, 2, 3, 4, 5, 6, 7th line, my lords.
Yes.
It was further held that it is also well settled that the power under Article 227 of the Constitution is not available to be exercised for indulging.
Precisely for that reason, sir. I think you're not reading that clause 10 the way it should be read.
Yes, my lord.
That is not meant for a 227 proceeding, sir. That clause 10 is not meant for a 227 proceedings.
This is, my lord, single judge also categorically stated that the 227.
Anyway, we don't agree with you, sir. We don't agree with you. All right. The present appeal is directed against. The present appeals are directed against orders dated against a common judgment dated 17th May 2013, passed by the single judge in OJC number 1175/2001 and writ petition civil 5067 of 2003. Both those writ petitions were filed by the present appellant. Were filed by the respondent. No, you say while OJC number 1175 of 2001 was filed by the respondent. Number 3, Dr. Chaudhary Nagendranath Mishra. Writ petition civil 5067 of 2003 was filed by the present appellant. Both assailing an award dated 22nd November 2000 passed by the presiding officer Labour Court Bhubaneswar in ID case number 97 of 1992, whereby the dismissal of the respondent number 3 by the management was upheld. Paragraph. The jurisdiction exercised by the learned single judge in the said writ petitions was obviously under Article 227 of the Constitution. Full stop. Against an order passed by the learned single judge under Article 227 of the Constitution, no writ appeal would lie by way of an intra-court appeal to a division bench of this court. Full stop. Consequently, the court is not persuaded, declines to entertain these writ appeals, but leaves it open to the appellant to seek other appropriate remedies as may be available to the appellant in accordance with law.
Your Lordship may kindly take note of my decision which I have submitted, my lord. 2017 5 pages.
All right. Counsel for the appellant refer to the decision in what is the cross title, sir?
1 minute. Well, it is Ramkrishna Fauji versus State of Haryana and others.
Ramkrishna Fauji.
FAUJ, my lord.
FAUJ. Ramkishan Fauji versus State of Haryana.
Yes, sir.
Having perused the said judgment, the court is satisfied that the present appeals are not maintainable.
In fact, with the Lordship's permission also, the full bench decision of Dishonorable Court clearly says 227 no writ appeal, that 2008 2 OLR full bench page 7 to 5.
2008?
2 OLR page 7 to 5.
Right.
And paragraph 47 clause 3. It says if it is 226 writ appeal will lie, 227 no writ appeal.
What's the cause title, sir?
And the cause title is Muhammad Saud, that is Muhammad Saud, SAUD and others, versus Dr. Major Sheikh Mahfuz and another. I am sorry, my associate should have been present with the reference of your lordship. Due to some personal inconvenience, it could not be done.
It may
But this
also
is
be
the
noted that
reference,
the full
madam.
bench of this court has in Mohammed Saud versus Dr. Sheikh. Sheikh what?
Sheikh Mahfouz, Mahfuz. Mahfouz.
Mahfouz. 2008 2 OLR 725. Bracket para 47 bracket 3. Held that no such writ appeal would be maintainable. Right. In the final order. Yes.
Passover matter, item number 48.
None appears despite a Passover. Dismissed. For not possible.
Item number 84 for hearing.
84 minute, I am hearing for the appellant. For the first time, my name has appeared pursuant to my lord's direction in the last occasion. I pray only 2 weeks time further.
No, sir. It's a 94 matter.
Bulky file, my lord.
Maybe, sir. We are also here. We'll help you. Don't worry.
Okay.
It's a 94 matter.
That's true, my lord. Only next week I'll prepare.
No, sir. We can't keep adjourning like this. 30 years old.
No, what happened, my lord? My lord, Justice Sahu was appearing previously.
Whatever, sir.
And all
you had enough
records,
time to prepare.
Records are also not with me, my lord. Even Honorable Supreme Court judgment is not with me. I am trying to get it. I'll also collect it from my learned friend, State Council. Lord, your lordship, take up this matter any day next week. Any day next week.
It's a 94 matter.
Yes, that I appreciate, my lord. I realize that there is a difficulty. I only because first time it has come.
There's no first time, sir. This is since 1994.
My name was not appearing inadvertently. My name was first time it has come. I pray only on Monday or Tuesday, anything. I'll come up with the notes so that it will be helpful.
All right. At the request of counsel for the
appellant number 1.
Appellant.
Respondent number 1.
Sorry?
Respondent number 1. I am for the respondent. State.
So let the state start, sir. Please. Why are we adjourning? What is this going on?
Sorry.
You start, madam.
Last occasion, I have already started, my lord. This is this case of double murder, my lord, if your lordship will remember. In Puri, regarding a kerosene depot, there was a motive like that kerosene, his license for kerosene was cancelled.
So it was already there last week.
Yeah, your lordship had heard it extensively. I had.
Then you were already there.
No.
He was not there. Inadvertently, I also was not able to inform him, my lord, because though I knew.
All right. At the request of counsel for the respondent. List on. Next will be 13th September, sir. 13th September. All right.
Item number 85.
Yes, please.
Here, my lord, the case I had argued, I had also, with the permission of my lord, had taken the records, but on a thorough scrutiny of the brief, I would find that the records are not helpful for me. That is applicable when accused has been, some accused has been remanded to custody. 172 has got application after that. If one will go the lines in between, let's say after remand of the accused.
Right.
Because here in this case, application for anticipatory bail was filed by the accused.
Right.
And in between 5 months have been passed.
Right.
So no record was desired to be sent by investigating officer to the court.
Right.
Here, my lord, the prosecution has, my lord must have remembered that the case occurrence has taken place at a busy place of Balangir town.
Right.
That is Palace Place
Correct.
line.
Correct.
The marketplace. And very pertinently, my lord, put a question whether any independent witnesses have been examined or not. Somebody, Iowa has examined any independent witness or not. Here, my lord, PW7, the wife of the deceased, has stated that my husband, who was staying with me in my father's place.
So this is where she comes. She's supposed to have seen the occurrence, gone back to her father, then come back again for the cremation.
My lord, not for the cremation, during postmortem.
Postmortem, correct,
Yes.
correct.
She has not attended the cremation. Postmortem, returned back again with her father.
Correct, correct.
And remained silent, not informed any villagers or anyone.
Correct.
The next day, police went to her place and examined.
Correct, correct.
Well, initially, the case of PW7 was, as I have verified from the records, that while the appellant was assaulting, other two persons were there. That was the version of her father, before whom she has disclosed first.
Right.
After returning to the village,
yes,
Chudapalli, she says, I intimated my father about the occurrence.
Yes.
Father was also examined under 161. She has also stated, my daughter has stated, why I'm saying so, why I'm referring 161 statement that has, in the case of this nature, Honorable Apex Court has said, for appreciation of evidence of this type of witnesses, one is to see the 161. Honorable, I was verifying his judgment by Honorable Justice G.V. Patnaik in the Apex Court, 2000 SEC matter. That's a case of this nature. When witness the conduct of PW7 is suspicious, she had seen the murder of her own husband.
Yes.
And that too, present appellant, her brother-in-law, younger brother-in-law. And she has also stated in paragraph 23 that I had a very good relationship with my brother-in-law. Even the brother-in-law had stated the name of my daughter. Mother-in-law was unmarried during that period. And when my husband was involved in murder case and attempted murder case, and he was convicted by the Sessions Court, the case was prosecuted. A course was entirely monitored by my brother-in-law and my father-in-law, for which he could be acquitted. Everything, family relationship was very cordial. This question has been put to the appellant at the stage of accused statement, and that is the defense case also, that at the stage of postmortem, PW7 saw me and asked for rupees 25,000 for her sister's marriage. And he denied that my brother has died. I have purchased a vehicle for him on loan. So at present, I cannot pay. Though my lord witnesses of PW1 who has been declared hostile by the prosecution, he said he has later on paid for the daughter's marriage. However, my lord PW7 has come forward to depose against me. My lord, I have tried to explain in my note, PW7 is the solitary eyewitness to the occurrence. If the case of prosecution will be accepted as it is, without any subtraction. The evidence of PW7, as decided by the Apex Court, by this Honorable Court, till date, that should be above board, above reproach, should be clear, cogent, and unimpeachable in character. While at the conduct of PW7, by returning to her place, again came mustering of courage, again came to Balangir during evening, again returned back without informing anyone. Because she says in her evidence,
yes,
she says in her evidence that I had to cross 2 kilometers from bus stand, private bus stand, taxi stand, rickshaw stand was there. She has crossed everything, police station, SP office, but has not intimated anyone. Is it probable for a common human being that she has seen the murder of her own husband and will calmly return back? Even in the bus, she had to cross around 18 kilometers to reach at her place. Even in the bus, she has not disclosed this incident to anyone. Even reaching at the village, not inform anyone, any village gentries or sarpanch or anyone, that my husband has been murdered. I have seen that, but I could not say anything to anyone. Please inform the police because it's around 18 kilometers only. That conduct, my lord, that has been deprecated by Apex Court in 76 Supreme Court and 79 Supreme Court. It also in the case of this Honorable Court in 88 was here. I have given the memo of citation. See if my lord will see that.
Right.
Bereft of that, my lord, we see the evidence of PW10, who is the doctor who has conducted post-mortem examination. It can be said, my lord, on the last occasion, my lord was also observing that she is the wife of the deceased. It is not natural on the part of the investigating officer to go to her place and to verify.
Right.
My lord, we see evidence of PW10 at page 86.
Yes.
I found, once I conducted postmortem examination over the dead body of
incised injury.
My lord?
Extending. Incised injury.
My lord, around 20 injuries, incised, abrasions, contusions, everything. And if my lord will see the nature of the injuries are on the front side, the back side, the left side, and the right side. Is it humanly possible by a single person to use in one hand cutlery or any sharp-edged weapon, in the other hand lathi, and will assault in the left side, right side, back side, front side, and having caused 20 injuries? My lord, as common knowledge, my lord, if a person will be assaulted by means of a sword or a cutlery or a bhujali, whatever it may be, 3, 4 blows, 5 blows, he will fall down. He or she will fall down. After one will be fell down, can he be assaulted, turning him in his back, again turning him from his left side and the right side? Injuries will be contusion, abrasion, laceration, and incised. My lord, and that too is IO. So, my lord, this witness in the cross-examination has also stated, this is, initially he has stated, this is not possible by a single person.
Yes.
My lord, at this juncture, I have tried to explain, my lord. My lord, it is respectfully submitted that the injuries are found
head to foot.
Head to foot, exactly. Head to foot on the front side, back side, right side, and also on the left side.
Yes.
Nature of the injury shows of different kinds of weapons. It can never be possible by one person to hold multiple weapons. If one can be Chadurabhuja, my lord, like Ma Durga, then it can be possible. The attempt of IO of introducing PW7 as a witness to the occurrence at a belated stage to say that the appellant is the only person who was killed the deceased can be discarded, and the prosecution's story to that extent can be disbelieved. Rather, the report under Exhibit 9 is consistent with the initial case of prosecution, where charge sheet was submitted against 3. Charge sheet was submitted against 3, charge was framed against 3, and the reasons best known to the prosecution witnesses, they completely given a go-by to other 2. Well, this situation has been taken note of by Apex Court in the case reported in 1998 Supreme Court 249.
Right.
Wherein, my lord, considering the observation, finding of the Florent High Court, because this is a case against order of acquittal, High Court has appreciated this fact and reached at a conclusion. The doctor stated the postmortem examination report does not show the injury was caused. Considering the fact that as many as 17 incised wounds were found on the body of Rajkumar Singh, the High Court found it difficult to believe that he was assaulted by only one assailant with sharp-edged weapon. The High Court opined there was more than one assailant armed with such sharp-edged weapons. The opinion of the High Court cannot be considered to be baseless or perverse. Here, my lord, initially the prosecution case was 3 because he was a hardened criminal. That is, my lord, they are available in evidence.
Right.
That after his death, entire Balangir town, my lord, they hosted it by doing feast, this, that, because he was a person who was regularly collecting booty from the shopkeepers, and he was creating havoc in that area. And he was not staying in that area. He was staying in his in-laws' place, coming sometimes, collecting chanda, booty, and creating disturbance. And even 2 days, that is there also in the record, 2 days prior to the occurrence, he has assaulted a saloon owner brutally, for which he was also taken as an accused in the case of 307. My lord, my attempt is, my lord, to show that whether my lord can see for the appreciation of evidence is 161 statement of the witnesses, those who were examined.
Yes.
That has been taken note of by Apex Court in 2000 SCC Criminal 285.
Yes, Padam Singh.
They are saying
that's a well-known proposition. Basically, to say it has to be examined with great circumspection.
no evidence. That 161 statement, they have given a go by and tried to fix up one person, whether their evidence can be taken note of. That is, my lord. I have stated, lastly, the London Council was, that is the case which was argued by my lord, senior counsel, the Apex Court. My lord, that is, my lord, even Bachawat. My lord, the London Senior Council also submitted that each of the contradictions and omissions relied upon by Justice Mathur in this judgment between the statement of the court and statement recorded under 161 makes the evidence of the eyewitnesses vulnerable, and therefore no reliance could have been placed on those testimonies to establish a charge of murder. Lastly, the London Council asked that it is highly unnatural that the occurrence is taking place inside the village. My lord had put me this question last time.
Correct.
And answer is, the London Council asked that it is highly unnatural that the occurrence is taking place inside the village in broad daylight, here in broad daylight at Palace Line, which is a crowd place. And only individual witnesses are being examined and not a single independent witness. And this creates a doubt about the prosecution case. But here, yes, PW7 is the wife. She had come as a chance witness and has seen the occurrence. But entire area was crowded. But IO says nobody was available to be examined. Nobody was available to be examined in that case.
Right.
And person, my lord, the husband, the father of PW7, who had accompanied Mr. Joshi, he has also been withdrawn from prosecution box to say what was said by his daughter and what was the observation, whether any police officer was available at the postmortem center or not. Prosecution is not bound to examine, my lord, all the witnesses. But law says, my lord, they should examine the witnesses whose examination would have unfolded the narratives. That is, my lord, 71 Supreme Court 1586, paragraph 15. The Honorable Apex Court has categorical stated, no, it's not necessary because evidence is always weighed, not counted, my lord. Here, my lord, considering the evidence of the doctor who says he has sustained, even, my lord, the inside, my lord will see a peculiar thing. Incised wound with a dent means if I have used, say, sword, another incised wound with a dent, my lord, that you usually used to cut sheep and goats. That is there. So definitely, my lord, closing the eyes, if my lord will view the situation, there were persons, those who have assaulted, petitioner, the present appellant has been made a scapegoat in the entire case, my lord. And I don't want to reiterate or repeat my submission with regards to the belated disclosure.
Right.
Here, the court has said even 10 hours delay is
correct. It's
because she is the what has been given by
Sorry, your note has been given.
I don't know whether to.
We got your note out.
Yes. All the judgments have referred with memo of citation have been given, madam?
Yes.
Madam. I don't want to take my lord's valuable time.
No, fine.
May I please, your lordships. My lord, at the outset, my lord, this is a case of solitary eyewitness.
Correct.
And your lordships have to be convinced that the solitary eyewitness is credible or not.
Correct.
Last occasion, your lordship asked me that she appears to be a chance witness.
Correct.
But my lord, an occurrence is not disputed.
No, it's homicidal death.
No, homicidal is not. No, what I'm saying is, my lord, occurrence at the place in front of the appellant's shop. She has the PW7 has very categorically explained how she has come, how she has seen the assault. And your lordship may fathom that a lady who sees her brother-in-law hacking the person with a sword, the mental state of mind, when she says that she had a good relationship with him, they have sharing a very good relationship, the mental trauma that she must have gone through, the kind of mental state she must be in. So my lord, your lordship knows Apex Court has, I'm sorry, I had that decision, but I'll place it before, that the conduct of witnesses in a particular occurrence can never be the same. Some may just become shocked, some may run away, some may raise an alarm, some may just become stoned, silenced. So the behavior of the conduct or behavior or the demeanor of a witness, of a person witnessing a ghastly occurrence can never be the same. It can be never presumed.
But she has returned back and again came in the...
Yes, that is what I'm saying. She, out of her sheer helplessness, shock, she has gone back. And she says that on her way back in the bus, she could not control her tears. And my lord, why should she disclose it with anybody in the bus who are all strangers? That is what my learned senior was asking. She never told this to anybody in this bus. Why there should be an occasion for her to divulge this thing to anybody in the bus? More so when it is her own brother-in-law who was hacked. She has gone back. She has gone back to her father. And also there was a question put by the defense that why she has not gone to some of her relatives' house who were also at present at that local people. She has candidly stated that she had no idea about their addresses. So she, in very naturally, to go back to her own father with some comfort, she has gone back. They have come back, seen the postmortem. My lord, all I'm trying to say, my lord, it is a mental condition of the woman who has seen. She must have enough courage and guts to come out to say that she saw her brother-in-law hacking the brother, my lord. And here, my lord, the point that has been raised by the defense is that belated examination of the wife who seems to be eyewitness. The prosecution, never had an idea that she is an eyewitness. It is out of the natural course of the investigation when he has gone to examine the wife, interrogate her, he has come to know that she is an eyewitness. And that is why she comes into the picture. So there is no lacuna on part of the prosecution that knowing that, my lord, from the very beginning, my lord, I had last occasion also, I had said, my lord, this is an FIR against unknown person. Then SI has given an FIR, unknown person. He has also stated in his FIR that from the kind of injuries that is found in the body, it is presumed that this is an homicidal death. So, my lord, he had no idea that who are the witnesses. And my lord, regarding non-examination of independent witnesses, my lord, there are a pattern of decisions of the Supreme Court, my lord, where, my lord, if I can just give some references, my lord. In Prabhunath Jha case, my lord, I'll place this. I had this bunch of judgment, but somehow inadvertently I could not get. In Prabhunath Jha, my lord, in 2003, 12 SSC 606, in Sadhu Saran Singh versus State of UP 2016, in Ambika Prasad versus State, my lord, State of UP in 2000, in Shamim versus State of NCML, all this decision there, where the Honorable Apex Court has held that nowadays the general insensitivity with the public has become very, has come to the forefront. Now the civilized persons, the people don't want to get themselves involved in some kind of crime. And that is the reason, my lord, the prosecution hands are bound at times when, though the occurrence happens.
These are all uninterested persons. See how a bystander will behave is very different from how a Close relative will be here.
Yes, my lord. And here, my lord, a close
So
relative.
those decisions are in the context of people not coming forward to participate.
Yes, my lord, for non-examination of independent witnesses. Point that my
you're jumping points now. The question now is somebody who's witnessed a ghastly crime. Let's say you're going by the road and you see somebody hacking somebody else. You are not interested in the outcome of that, correct? You say, why should I get into this? Let me carry on with my life. These decisions are about those kind of people.
Yes, yes. I'm answering to my learned seniors.
You've gone to some other point. I thought, okay, you're finished. You're finished the first point then.
No.
You've gone to some other point
No.
altogether.
I'll come back to PW7, my lord.
We are still on that point.
Yes, sorry, my lord.
Sorry that we have not been able to match your speed at going to some other point.
In my anxiety, well, So coming to PW7 also, Honorable Supreme Court has also stated, my lord, in Samim versus State of NCT, my lord, and Hotam Singh also, my lord, in versus State of MP, my lord, that generally in a criminal trial, my lord, there is a difference between interested and related witnesses, my lord.
You're not on that again.
This is a related witness, my lord.
No, don't. So these are separate points altogether. All right. We are now only on the conduct of PW7, having witnessed the occurrence.
Why should she try to shield a actual culprit?
No. We are again, don't ask those. Let's focus on her conduct. As soon as she sees the crime, she travels back to her village, right? She does not stop, does not talk to anyone. She just boards a bus and goes to her house. What is the distance and how long do you think that takes?
Half an hour she goes back.
And then she's there in her house with her father, correct?
And she comes back.
No. When does she come back?
She comes back when the body has been taken for postmortem.
No. How many hours later? How many hours later? See, we have to assess the context of all these times.
Yes, my lord. Honestly, that, my lord. The incident takes place at 10. The dead body is taken for postmortem around 1:45.
No. She has
come after that.
No. So she was there at 10 o'clock when the murder happened. And then she goes to the bus stop, boards the bus, goes back to her house.
Yes.
There she is with her father.
W7. At para 5, my lord, she says, on my arrival in the place line, para 4, my lord. On my arrival in the place line at about 12 noon, I saw accused Achyuta dealing sword blows on my husband in front of his shop. As a result of such assault, my husband sustained injuries and fell down. Seeing the incident out of fear, I returned to Chudapalli and disclosed regarding the occurrence to my father. On hearing regarding the occurrence from me, my father along with me came to Balangir on the same day. At Balangir, my father left me at the bus stand and went to inquire regarding the incident. He returned and told that the dead body of my husband had been taken.
One important thing is that she's deposing on 23rd October 97.
Yes, ma'am.
Which is 1 year and 4 months after the 6 months, 1.5 years after the occurrence. Right?
Yes, my lord. So, my lord, when trial commences after such a long period, it is only general that there are some tribal omissions and
no. So this is an examination chief, so she's very clear about what she's saying now.
Yes. The bus stand went to inquire regarding the incident. He returned and told that dead body of my husband had been taken to the hospital.
No. Did she speak to her father?
Yes, my lord.
When she went back home, did she speak to her father?
And this at para 4, my lords. And disclosed regarding the occurrence to my father at para 4.
So her father is also traumatized, that he's also silent? Is that your case? He's also equally traumatized, so traumatized that he will not even go to the police?
But because by the time they've come back, already the FIR has been...
No. So you continue remaining traumatized till evening when you're seeing the postmortem. Even then you do not want to tell the police. Forget about telling anyone else. Why would you not tell the police?
Yes, my lord. Your lordship, there's a point there, my lord. But can I continue on para 5, my lord?
Yes.
At Balangir, on hearing regarding the occurrence from me, my father along with me came to Balangir on the same day. At Balangir, my father left me at the bus stand and went to inquire regarding the incident. He returned and told me the dead body of my husband had been taken to hospital for PM examination. We went to the district headquarter hospital, Balangir, where my husband's dead body had been kept. After seeing the dead body for a little distance, we returned to Chudapalli.
This is the whole point.
Yes.
Okay, up to this. Is this a normal conduct?
It is indeed a normal, it is not normal, my lord, but my humble submission is, my lord, it is very difficult to comprehend the conduct of a human being who has witnessed a ghastly occurrence by a relative, near relative, my lord, brother-in-law, because, my lord, she must have had so much of...
No, because you have to see it also in the context of first an FIR being lodged against 3 persons.
No, FIR is against unknown person.
No, okay, charge sheet is against.
Charge sheet, my lord, during charge sheet.
During the course of investigation, names of 3 persons emerged. How did that emerge? Because there is no other witness.
No witnesses came forward, yes, ma'am.
No other witness.
No
came
other
forward.
witness.
Please don't say no witness.
No independent witnesses. No independent witnesses came forward to...
There is one witness who should be the only source for the police to name 3 people in the charge sheet. Correct?
Yes, ma'am.
Who could be the source of the other 2 names? Who could be the source of the other 2 names?
That the IO, my lord, has not...
No, you tell us. How will the IO suddenly pick up 3 names? If she's speaking the entire truth and she saw only one person commit the murder, how did the other 2 persons emerge? And from whom?
And charge was also failed.
My lord, the IO says that in course of investigation, I examined the witnesses and recorded their statements, my lord.
Correct. Who could have given him names of 3 persons? Let us go into that. Who could have given him the names of 3 persons?
My lord, for this, my lord, I need to go through the...
Go through it because it's see, the thing is, it's such a critical stage because no police officer suddenly randomly picks up in a sensational murder case like this. He doesn't simply pick up 3 persons, right?
No, my lord, I was also very perturbed with that fact, how, from where these 3 person name came and why they were suddenly dropped. So,
not dropped. Actually, the police did not drop them. The police did not drop them. The police maintained it as a murder by 3 people.
I conducted spot visit at 1:50 p.m. I held in, but the police says that there was
the problem with this witness is she could still say, I saw 3 people attack my husband.
Actually, my lord, 2 persons, and shopkeeper and PW 2, 3 and 4, they have turned hostile. So where, my lord, your lordship, I can take them to but since it is redundant, my lord, there are people who have, we have seen the witnesses, we know about the witnesses, but they have turned hostile.
No.
So
but even in a hostile witness, if there's some portion of that hostile witness's statement that can help the prosecution, there is enough case law on that.
Yes.
Yes, my lord, you can rely on the hostile witnesses.
Correct.
Yes, my lord, that is there. These 2 witnesses who have turned hostile murder, they have said regarding the occurrence, but they have not named anybody, and that they say that they have not seen anybody.
So
that is
the
honest.
problem. So your problem is today, suddenly 3 people have emerged. Your star witness does not say that she saw more than 1 person.
Yes, my lord. And star witness also, my lord, I should consider.
Therefore assessing the reliability and truthfulness of this star witness. The only witness.
The only witness, my lord. I can only make my submission on the basis of that only chance witness, my lord. She's a chance witness, but my lord, she's a related witness, my lord. So my humble submission is that why would a related witness, a wife, if she at all has seen an assault by 3 people, she would like to shield the real assailant and falsely implicate her own brother-in-law. When she has already stated that they were having good relationship, he has named her, he has named his shop in the name of her daughter. When there was so nice, cordial relationship between the brothers, why would she falsely implicate this man?
That per se will not answer the question, right? That per se does not answer the question.
My lord, can I have an occasion to see the 161 statement?
Yeah, please, by all means, by all means.
Is there.
So-
Again, like yesterday,
Verified that it is.
the LCR.
2%.
Please ask, see, find out if the LCR is there.
My learned
But
senior
it's not
says that
there, like
she has
yesterday,
stated the
he
names
has
of the two.
So not names. 2% were there.
Like that in each of these criminal appeals,
Very-
wherever it says LCR,
The permission of the
barcode number,
taken.
you have to make sure.
I think just because she happens to be a chance witness, by chance she happens to be there, my lord.
Please, it's not just, there's enough case law to say even a chance witness, if it's a reliable witness, we
Yes,
can
ma'am.
still rely on. Let's say there's a very brave chance witness who's watching from a bus. He's traveling from A to B in a bus.
Yes, my lord.
It's passing through the main road. From the bus window, he's seeing a murder happen. He may pick up the courage to say, no, I want to be a witness in this case, and still come and depose. And if he's reliable,
But
the deposition can form the basis. We are not on that. Ultimately, the intrinsic worth of the witness has to be on the conduct of the witness itself and what the witness is saying. See, suddenly this witness is telling us, I saw only one person alone commit this murder, and that happens to be my brother.
No, my lord, my learned senior says he has gone to the 161 statement. She has named that two other persons. She has said.
2 persons were there, and ultimately, the other persons have been examined. They said the names, and ultimately, charge sheet was submitted. Charge was framed against them. But in the trial, as because no evidence could come, my lord, 13.
So that is what I wanted to verify, my lord, if you lordship.
So then the question would be, why would she not name the other two in the trial? That will become a valid question, wouldn't it? Equally, like you are saying, why should she accuse her own brother-in-law?
That part has not been put to her in the cross-examination, my lord.
Prosecution is to prove its case.
No, why she has not named that she could have been cross-examined on behalf of the accused on that point.
No, the question is the burden is on you. The burden is on the prosecution.
She has stated something in the 161 statement, and why is she not stating in a deposition, my lord? That could have been
the court can certainly ask, isn't it?
Yes, court could have asked, my lord. But the defense also had an opportunity to ask her regarding that, my lord.
No, if it doesn't help the defense, they will not ask.
I'll see that 161 statements, and I will convince the lordship on the conduct of the witness, my lord.
It's very interesting. Since she has not named the other accused persons, you just see the cross-examination by other accused persons declined.
Yes.
Just see this. Cross-examination on behalf of the other accused persons declined. And she's a star witness. Since she's not naming them at all, they have no occasion to cross-examine her.
Yes, ma'am. He has been cross-examined on behalf of accused Achyuta only, my lord.
That's right.
Yes, ma'am.
Don't you think it's significant? In a murder case,
She says, my lord, I did not notice anyone else in the vicinity of that at that time.
So this is so
This
significant.
question was asked.
So this kind of a deposition clearly helps the other two accused, right?
Yes, my lord, regarding benefit of doubt should go, my lord. But
no, that star witness would completely be silent on the other two accused to the extent that they don't even have to cross-examine her. She's not naming them.
and why she ran away from the place, my lord? She has explained, my lord. She's out of fear of my life. I rushed back to Chudapur.
That is at 12 noon.
Yes, when she said.
When you come back for a postmortem, what is that? Either you shouldn't then don't come back at all for postmortem. If you're running away from fear of your life, don't come back for postmortem.
She has come back with the support of her father.
Right. So by then the fear is gone then. Let's be clear therefore.
No, father has gone for enquiry and then come back and told her that they have taken to the hospital.
Correct.
He has gone to that spot and he has found that he has already taken, body has been taken for
Correct.
postmortem. They have gone there.
So there's no fear at that time. So what prevented her or even the father from speaking to the police, even at that stage? So you do one thing, you examine the 161 statements, both of the father and her.
I verified that.
I know, but let her do it.
I'll show her.
You have I'll take the copies from.
All right. No, so we can hear this tomorrow, day after, whenever but we'll carry on with the board now. After
Yes. Any day.
All right.
88 of the supplementary list, Your Lordship. Your Lordship, here the assessment order has been challenged under VAT Act, Your Lordship. And Your Lordship, on the last
89.
88.
He is referring to 88. I appear for the
88. Ha ha ha.
Your Lordship, on the last occasion, Your
Why
Lordship.
is it partnered or something?
No, Your Lordship.
Ah,
Your Lordship,
go to
I
the
think-
assigned
I
bench.
think we're on
My
the-
lord, may I just point out, my lord, there may be a reason why it is not gone to the assigned bench. I was sharing it with Ms. Mishra in the morning. Probably Honorable Justice Raman may have dealt with the matter.
No. I have verified. I checked up my record.
While my lord, Mr. Ashok Mahanti was the senior standing counsel of the Commercial Tax Department, Mr. R.P. Kar and Mr. M.S. Raman, my lord, now Honorable Justice Raman, may have dealt with the matter. Therefore, it is coming before your lordship.
No, Your
No,
Lordship.
let him recuse if it is.
Your Lordship.
You see, before the assigned bench. We'll have it
May I
tomorrow.
only pray that the interim order be kindly continued.
Yeah. Between today and tomorrow, Mr. Das, if something happens, please mention it. It will be a record of sorts. I'm listing the matter tomorrow, and between today and tomorrow, if they start recovering, then let me know.
May I just, my lord, may I just point
On the
out,
last occasion, Your Lordship was
unfortunately,
directed
on the
to
last
submit
occasion when your
the
lordship was
assessment record, Your
extend the
Lordship.
interim order, it's not reflected in the order sheet. Hence, I'm praying, my lord.
All right.
Your Lordship, on the last occasion, Your Lordship was directed to produce the assessment record. Your Lordship, I have called for the assessment record. It may take some time, Your Lordship.
So next week then?
Lord,
One
it's
week
coming
after,
from
Your
Jaipur,
Lordship. I think
Koraput.
Jaipur, Your Lordship. 1 week after, Your Lordship.
All right. So you say list on 13th September before the roster bench, interim order to continue.
I'm deeply obliged.
All right.
In a criminal appeal, I'm filing a written note of summons.
All right.
Your lordship had on 30th.
All right.
Item number 85 for hearing.
My lord, I had shown my learned friend the 161 statement that is there in the case diary as well as in written.
I would like to, I have requested him to give me a copy, Xerox copy of that. I'll take it from him, my lord. Will Lakshmi grant me 1 day time if possible?
no problem.
So specifically, father, wife, everyone stated that.
Wife is saying in the 161 that 2 persons were standing near the standing there, but she has not mentioned assault. But the father says that my daughter came and told me that my brother-in-law as well as 2 other persons were assaulting.
All right.
So that is there, but I would like to again go through it.
All right. We'll take it up tomorrow.
Tomorrow, my lord. My lord, may I pray, my lord? Yesterday, my lord was pleased to direct me to take the copy by opening the barcode. I have taken all strain and prepared a short note on that. So can that matter be taken up tomorrow as to be mentioned so that I can add this?
Which is that matter?
I have prepared a note and I will give the.
It's in the weekly list, no?
It was.
Item 1, my lord. Item 1.
I argued yesterday.
It's still there, I think.
No, my lord.
It has been closed, my lord. Hearing closed.
Hearing closed.
Oh, you submit a note, sir. You submit a note.
Because in the absence of the file, how can so ballot from the evidence of PW 13, he has stated so. This question has been put specifically to him.
You put it all in a note, sir. No problem.
Okay.
Just put it in a note.
But unless I will say that.
No. You can take it as if we'll imagine that you are actually arguing before us when we read that note.
Well,
all right.
For that reason, I was saying for 5 minutes.
No, sir. Once it is reserved, you just give a note. That's enough.
For that reason, I was saying not as hearing, but to be mentioned.
Not necessary, sir. Not necessary. Right.
My lord, this 85 will take tomorrow, day after tomorrow.
Tomorrow.
I'll give that note tomorrow.
All right.
Item number 86.
I am in criminal appeal number 391.
Right.
There are 2 appeals. I'm not in the other one.
Who's in the other one? Devasnan Das.
Mr. Panda was there, I think.
Who's in the next one, sir? Who's in the other appeal?
I don't know, sir. List, madam,
the list, cause list is Devasnan Das.
I'm submitting my note of argument.
But in the next appeal, they're all in custody. The appellant is in custody in the next appeal.
My lord.
What about your appellant?
He's in also custody.
So why is nobody appearing when he's in custody? They should be appearing at least. Although the name of Mr. Devasnan Das is shown in the cause list as appearing for the appellant in criminal appeal 465 of 2014. Appeal is today on behalf of the appellant. Notice without process fee will issue to Mr. Devasnan Das as well as to the appellant. No, appellant is in jail, no?
My lord.
To remain present at the next date. Simultaneously, the Secretary, High Court Legal Services Committee is directed to assign a lawyer of not less than 10 years experience for the appellant. One set of the paperwork made available to the by the registry to the Secretary, OHC LSC, forthwith to enable him to assign, in turn hand it over to the assigned counsel. The assigned counsel of the OHC LSC will get in touch with the appellant for instructions before the next day. Give this back to him. List on 28th September.
My lord.
Repeat the date. The mic clearly. Repeat to him the date. Speak into the mic and repeat the date I have given. Kindly listen. Kindly speak into the mic and repeat.
Item number 87. '87.
At 1721 of 2014, we say fine collection to state till the then 1722 none appears, dismissal, non-prosecution. 947 is a more recent application. 947 of 22. None appears for the appellant. Dismissal, non-prosecution.
Last occasion also, my lord, none had appeared. 27, 22.
This appeal was earlier listed on The last listed on 24th June, sorry. No. Then 20th July somebody appeared, SK Pradhan.
Well, 20th July, no one had appeared.
25th July.
20th.
No, 20th July.
27, 2022, my lord.
No, 27, 2022.
Yes.
This is 585, no?
585 melodies.
It says SK Pradhan. But although the second paragraph says none appears. All right. You say on the previous date, that is 20th July 2022, none appeared to the appellant when the matter was called out. Even today, none is appearing on his behalf. Notice without process fee be issued to the appellant. Is he on bail?
No, my lord. My lord. Number of times this has been listed, no one has appeared, my lord. Even prior to that, my lord.
All right. Notice of process fee be issued to Mr. SK Pradhan, advocate, to remain present on the next date. There's also a Miss Aditi Hota. She appeared on some dates. Anyway, simultaneously, the High Court Legal Services Committee will assign it. So the last line, same order, the previous matter, and give it the same date also. You see the last line, you say copy of this order be sent forthwith to the Secretary, High Court Legal Services, both matters. 28 September.
Your Lordship is referring to the legal aid for...
Correct. Appointing a counsel. Correct.
Item number 89.
May I please, my lord, in this case, I am appearing for criminal appeal number 622 of 2015.
Right.
In this case, I have filed an interim application for bail. I am in custody since 26, 2007, my lord.
Right. We are ready to hear the appeal itself, sir.
For hearing the appeal, I may pray let it come in another date, my lord, so that I can prepare myself for hearing.
You're not ready to argue the appeal today?
I am also ready, but I need time.
You're ready, but you need time? We are a bit confused, sir.
Not fully ready.
All right. All right. Who's in the third matter?
I am there in 526 and 543. There the convictions are under 386 read with 120 and sentence of 10 years and fine.
Right.
I am not concerned with the main appeal of the appellants. That is Sanjay alias Bhavani Shankar Naik and Julu alias Raja alias Sarat Sahu alias Sarat Sahu.
So you're in 526 and 543?
Yes, my lords.
I see.
There my conviction is only 386 read with 120B. Sentence is 10 years, fine of 20,000. In default, RI for 2 years.
See, your clients are on bail?
Yes, my lords, they are on bail. And there is one other problem which I found out from the paper book. I think the paper book has to go for correction. Both my clients in criminal appeal 526 and 543, they are implicated on the basis of a FIR registered in 2008. That is Balangir Town PS case number 10 of 2008.
Right.
That was registered on an FIR by PW 28, the wife of the deceased.
You just see in criminal appeal 526 and 543 of 2015, Mr. Devashish Pandal on counsel appearing for the appellants in both these appeals points out that the paper book of the criminal appeals in both these appeals, paper book in both these appeals required to be rectified by including a typed copy of the FIR number.
Balangir Town PS case 10 of 2008.
Balangir Town PS case number 10 of 2008. The registry will do the needful before the next date. So list on 29th September. And the other two.
May I make a small prayer?
Yes.
29th September, my lords, I may be going for performing the Asti Visarjan of my mother that week.
All right.
Can it be after the vacation? First
All right.
week after the Puja?
13th October.
Yes.
13th October, and then other two appeals, 622.
They have to be heard together, my lords. Your lordship has
Charge and offense under section 302 IPC.
Yes.
Convicted for imprisonment of life.
Right.
The prosecution story reveals, due to some dissension with her husband, there is family disturbance aroused, the appellant murdered his deceased wife. The appellant was in custody from 8/10/2011 till now. As per judgment, it revealed paragraph 12, 13 and 14. The case is based on absence of any motive, and paragraph 13 is held that culpable homicide is not amounted murder, and paragraph 14, Lorraine Tribe held that regarding murder is based on intention and knowledge. So far, my lord, regarding intention is concerned, the Lorraine Tribe Court held to inflict injury, and regarding knowledge is concerned, injury caused to death. While the deceased along with co-villagers went to the forest to collection some firewood, there the appellant reached and used some axe and attacked to his head and neck. Thereby, the deceased shifted to hospital and their death. And the Lorraine Court observed the eyewitnesses are 2, 3, 6, 7 are the eyewitnesses. So far it is concerned that they are corroborated to each other. My lord, kindly have a glance to the deposition copy of Schedule 2, my lord. 2, 3, 6, 7 are the eyewitnesses of this case.
Yes.
Schedule 2 said, my lord, I am reading out.
Yes.
With my lord's permission.
You have permission for everything, all arguments, full permission granted, sir. Yes.
The operating portion is that while we were collecting files, hearing hulla from deceased, immediately came to the spot and found the deceased lying on the ground, and the accused was running away from the spot. This is the PW2 statement.
Right.
Then PW3 statement is that from the top 1, 2, 3, 4, 5, 6th line, the accused suddenly coming from the forest dealt a blow by means of an axe at different parts of the body of the deceased. As a result, the deceased fell to the ground. On reaching the accused, fleeing away from the spot. Then PW6 is from the top, 5th line. At the relevant time, I found the accused chasing the deceased and assaulted her by means of a tangia on her head, neck, and other parts of her body. Out of assault, the deceased fell down on the ground, though the accused and deceased of different caste had involved in mutual tie. There was no cordial relationship between them. Then PW7 stated on his deposition copy, 5th line from the top, we saw the accused assaulting Phulamati deceased by means of tangia on her face, neck, back. On hearing hulla, we went to the spot and found the accused fleeing away from the spot, leaving the tangia there. We heard hulla, we found the accused and deceased were there at the spot. As per this statement, the PW10 is the doctor who has postmortem the deceased. In his cross-examination, he said, all the injuries except injury number 7 are found on the left side of body of the deceased. The size of injury number 1 and 4 are similar except depth of the wound. Injury number 1 is grievous in nature
length and breadth of the injury number 1 and 4 are same. Injury number 1 cannot be possible on fall on sharp cutting object. It is not possible if sharp edged stone came in contact. Choke wound cannot be possible by any sharp edged stone. Laceration can be possible on coming into contact with sharp edged stone. It cannot be possible by sharp edged lathi. There is distinction between sharp cutting iron, bamboo, and sharp stone. I have not mentioned the color of the wounds in the PM report. This is the disposition held by the doctor. And the cause of death, as mentioned, due to hemorrhage and shock, homicidal in nature. And the case also based on circumstantial evidence regarding finding of human blood eggs. These are the main grounds that the appellant is in question more than 10 years. May I?
All right. Orders reserved. We'll pass it. All right.
Deeply obliged.
All right. Thank you, sir.
Item number 91.
On behalf of Sukhant Kumar Mishra in Criminal Appeal number 45 of 2018.
Yes.
He is suffering from viral fever.
All right. Who is in that second one? Prasanna Panda. Criminal Appeal 222 of 2018. Counsel for the appellant in Criminal Appeal 45 of 2018 is stated to be unwell. It's on 29th.
29 September, my lord?
Yes.
September.
Item number 92.
I am for the respondent.
In this case, my lord, SP Mishra, senior advocate, has been engaged.
My lord, I am appearing on behalf of my learner, senior my lord. He is on his leg, my lord.
91.
Reverend Samadhi, counsel for the appellant stated to be in some difficulty today. 7 December.
It will be. I am out of service. I am out of service. I have filed a contempt application. Despite the judgment passed by the Honorable Single Judge, I have not. Can you also keep it a little bit early?
Okay. 17 November. Sir. All right.
Your lordship.
17 November. All right.
With the lordship's permission, my lordship.
Yes, please.
I beg apology. Item 62 mentioned the appeal. I filed an IA for withdrawal of the writ appeal, your lordship.
Correct. We've allowed that.
My lordship.
Supplemental. Weekly list, item number 2.
Anyone waiting for any? This is becoming a daily story. Nobody in the weekly.
In item 2, my lordship,
yes.
on the last date, argued on behalf of the appeal number 1 to 4 has already concluded. Only 5 and 6 are remaining.
Yes.
We need some time, Mr. On behalf of Mr. Dhala, your lordship. 5 and 6 is concerned.
Mr. Dhala was there, no, in the morning?
Lordship, tomorrow, day after tomorrow, your lordship.
All right. He'll stay on board.
Next week, your lordship.
No. Just can go on. Okay, let's finish it. It's a 1996 appeal. Yes. It will stay on board.
My lordship.
Item number 3.
What about Mr. Panda? Yes, Mr. Panda.
Please, my lords. Please, my lords.
Yes.
Am I audible, my lords?
Yes, yes.
I may be permitted to place it, my lords. Mr. Panda is not in the fit state to argue at length in an appeal. He's feeling breathlessness. That's
all right. All right.
My lords, here, my lords, the appellant who was since, I'm sorry, my lords. My lords. The appellant herein before my lord is convicted under sections 302 read with 34 and 201 read with 34 of the IPC, my lord.
Right.
He had tried along with 3 others who were acquitted in the trial, my lord. Now the occurrence happened in the year 1998 where an FIR was lodged bearing a UT case number 3 of 1998 was registered and Montana PS on appellant's written report relating to the suicidal death hanging of his elder brother's wife, the deceased being Supala Sahu, on 27/3/1998. And in the course of investigation, my lords, the plain paper FIR was drawn up against unknown persons. And in the course of inquiry, it has come to light that the body which revealed in the postmortem, the death was due to
You're not audible, Mr. Panda. There's something wrong with the connection.
I'm sorry, my lords. My system got hanged. I'm coming from another system, my lords.
All right.
Am I audible now?
Yes, now it's better.
My lords. Here, I may be permitted. But here, the appellant was facing trial with 3 others who were since been acquitted in the case, ST case number 120A of 1998.
Yes.
The FIR instituted basing upon a UD case number, my lords, on the basis of the report that a suicidal death by hanging of the informant's elder brother's wife, Supala Sahu, my lords. And in course of investigation, the plain paper FIR was drawn up against unknown persons, my lords, and subsequent to that, my lords, the dead body was recovered, my lords, the dead body revealed that the death was due to asphyxia, and postmortem ligature mark was seen over the neck below the thyroid cartilage, continuous in nature. And therefore, cause of death was not suicidal, but homicidal, which has been reflected in the judgment, page number 23 to 32 of the paper book. My lords, may I place the relevant portion of the judgment, my lords, for my lords'
Yes.
kind appreciation?
Yes.
My lords. My lords, the learned court below had framed, my lords, I'm reading page number 12, which starts with the background and the main point of consideration before the learned court below.
Yes.
First was whether the above noted accused person having common intention committed murder of the deceased Supala Sahu by intentionally causing her death. My lords, point number 2, whether the accused person caused disappearance of certain evidence with intention to screen the above accused persons from legal punishment.
Yes.
In order to substantiate the charge against the accused person, the prosecution has examined as many as 15 PWs, including the IO and the doctors. No witnesses were examined before the defense. Out of the 15 witnesses, my lords, on behalf of the prosecution, PW1, Man Gandhi Sahu is a witness to the inquest. PW2, Purandar Sahu is an independent witness. PW3, Kuna Sahu. And Umesh Chandra Sahu is the husband of the deceased who was staying at Cuttack at the time of the incident. But all are family members of the present appellant, my lords, here. Because the deceased was the elder sister-in-law of the appellant, my lords.
Yes.
Well, here, PW41 Vijay Deori is a car driver at Nalco from whom the accused informed the incident at night in order to inform the incident at Katak to the husband of the deceased. PW5 Sunya Sahu is a relative of the husband of the deceased who came to know of the incident at 5 p.m. on return from his work. PW6 Athani Sahu is also the independent witnesses. 7 and 8 are mother-in-law of the deceased and the elder brother of the husband. 9 is one independent witness, namely Sripati Pradhan, and PW10 Kambu Seti, and PW11 is the doctor who examined the deceased, my lords. Which is relevant, my lords, I'll come across to that. PW12 is another doctor who jointly conducted the postmortem examination. PW13 is one Srinath Pradhan, who is the father of the deceased, and 14 is Usha Pradhan, who is the mother of the deceased. My lords, the entire story of the prosecution reveals on PW13 and 14, who were not arrayed as charge-sheeted witnesses, my lords, but subsequently they have come up in course of trial under 313 CRPC, my lords.
Yes, please.
Which has been categorically stated by the learned trial court, saying that PW13 and 14, who are the father of the deceased and mother of the deceased respectively, were examined under 311 CRPC, which will be, my lords, 319 CRPC. And Brajokishore Naik is the investigating officer, my lords. Now, my lords, I may draw my lords' kind attention to running page number 22 of the paper book.
Yes.
My lords, running page number 20, my lords.
Yes.
The relevant para is, my lords, here from the para number 14. From the medical evidence, it is clear that the death of the deceased was homicidal, which the learned trial court came to the conclusion, and it was due to asphyxia caused by certain injuries. The ligature marks said to have been found in the neck of the deceased were antemortem in nature. So the death of the deceased on account of struggle, my lords. The accused, the present appellant, had tied a rope in the neck of the deceased to take the plea that the deceased committed suicide. There is no evidence to show who cut the rope from the ceiling. Therefore, from the evidence of PW 13 and 14, it is abundantly clear that the accused Dhodia, who is the present appellant, was the author of the crime. This is the relevant portion, my lords, where the trial court has come up against the appellant, where it has stated, my lords, therefore, from the evidence of 13 and 14, it is abundantly clear that the appellant was the author of the crime. Now, my lords,
Yes.
may I place the evidence of 13 and 14?
Yes.
My lords, I will place them and show, my lords, that all the statements, they do not amount to confession. This is a case where res geste can take place, my lords, and I rely upon one judgment of the apex court, my lords, here. My lords, PW 13 is at running page 65 of the paper book. My lords, he has stated like this: he is the father of the deceased. The deceased Sufala is my daughter. The deceased Sufala is my only daughter. At the time of death of my daughter would be at the time of death, my daughter would be 24 to 25 years of age. My daughter Sufala had died about 1.5 years back. She had married to Punna Sahu, who is PW3, who has been also deposed, my lords, of the village Naukata at about 4.5 years back from today. My son-in-law has 2 brothers and 4 sisters. My son-in-law Punna Sahu is the middle brother, and the appellant, who is Dhodia Sahu, is the younger brother, and Sada Sahu is his elder brother. At the time of marriage of my daughter, so far
You have to unmute yourself, Mr. Panda. Kindly unmute yourself.
Something. Am I audible, my lords?
Yes.
My lords. My lords, at the time, my lords, I'm reading para 2, last line. At the time, all the sisters of Punna PW husband of the deceased had already married. At the time of the death of my daughter, her mother-in-law was alive. I had given all the articles cash as per demand of Kunasau and his family members. The mother-in-law of the deceased daughter told that her younger son, who is the appellant, being drunk, killed my deceased daughter along with others. And this is the relevant paragraph. It has come into picture only after the evidence of PW 13 and 14, which were recorded in trial under section 313 of the CRPC, because they were not charge sheeted witnesses, Milords. After a lapse of 2.5 years when the trial commenced, this story is deposed by PW 13 and subsequently by PW 14, Milords. Milords, mother-in-law of my deceased daughter told that her younger son, Dhadia, being drunk, killed my deceased daughter along with others. The village of the accused Dhadia would take about 2 hours to go to my village on walk. My daughter has expired on the previous evening when I got information from the elder brother of my son-in-law. I got information regarding the death of my daughter at 12 noon the next morning. My deceased daughter was alone at home. Her daughter had already expired, so she was alone residing at her village. The deceased daughter has expired. This is the defense, Milords, here, Milords, that she had committed suicide because she was not able to bear the fact that the child of the deceased, who were just a few months old, died due to some circumstances, Milords. I saw my deceased daughter had sustained bleeding injuries on her face and there was ligature mark on her neck. We reached at the spot. Her face had been covered by cloth. I saw injuries in the other parts of the body of the deceased. My wife and my family members accompanied me to the village of accused Dhadia. The accused Dhadia was residing in the left side room of the deceased daughter alone. He was unmarried during that time. Prior to this incident, my deceased daughter complained against the accused Dhadia that the accused Dhadia used to misbehave my deceased daughter being drunk. Even once the accused Dhadia went to her house and created, my lords, I'm not able to read that word, probably Gondogol with my deceased daughter. I had got information, this matter, to my son-in-law, but he is a calm-minded man. He did not tell his mother anything, not to misbehave my deceased daughter. Out of fear, my son-in-law did not dare to say anything to his younger brother, accused Dhadia. Accused Dhadia used to assault my daughter. Deceased daughter went back, for which my deceased daughter went back to Cuttack along with my son-in-law. After some months, she came to her village to see the cultivation of onion and garlic. During this period, the incident occurred. When I saw my deceased daughter lying dead, I suspected that accused Dhadia had killed my daughter. This story has come up in course of the trial once PW 13 and 14 have been examined. He has for the first time stated to have suspected that the accused Dhadia had killed my daughter. The mother of the accused Dhadia also told that the accused Dhadia had taken liquor in the previous night, so he might have killed my daughter. Milords, this is what the learned trial court has held to be a confession, Milords, under section 6 of the Evidence Act, Milords. I would claim that. So he might have killed my daughter. Accused Dhadia was absent from the spot when I reached there. Police arrived in the village. Thereafter, they took the dead body of my daughter to the hospital for post-mortem examination. I went to the PS and lodged the report at the PS. Milords, my submission so far as the lodging of the FIR is also concerned, as my lords may see, the FIR was registered as per a UD case on registration of a UD case against unknown persons. If around that time, Milords, PW 13 was there and it was told by the deceased mother-in-law that appellant had murdered him on being drunk, there was at no point of time that his name should not have been there in the FIR, or an FIR to that effect should have been lodged, my lords. Describing the entire, I went to the PS and lodged the report at the PS, describing the entire events leading to the death of my daughter. I had also mentioned the name of Dhadia in my report. On my oral report, police reduced the and I put my signature in the paper. Before my arrival at the PS, the family members of Dhadia had gone to the PS and had lodged the information. Police arrived at Naukata village after my report at the PS. Hana Babu did not take me to the village of my deceased daughter. Hana Babu did not examine me. Only the elder brother of my son-in-law went to the village and informed us regarding the death of my daughter, Sofali, at 12 noon on the next day. None informed us in the night of the death of my daughter, my lords. Whereas in cross-examination, he has stated, I had not disclosed this matter to anybody except today, as none asked me regarding this matter. My lords, may mark this. This is the relevant part, my lords. In cross-examination, para 6, I had not disclosed this matter to anyone except today, as none asked me regarding this matter. I had reported this incident to the Thana Babu, who has come to the court to depose in this case. I came in a bus. I halted at Angul in my brother's house. Today, I came to the court along with police. I do not remember the name of my brother. My lords, para 7 of the cross-examination. I had not informed the incident of assault and abuse of the accused Dhadia to my deceased daughter at Nuakheta to the police. The matter was settled between us. There is a document to the effect for amicable settlement. My elder father and his wife also accompanied to see the dead body of my deceased daughter. There are rooms at a distance of 15 cubits away from the room of my deceased daughter. I cannot identify any other person except accused Dhadia. I had not seen at the time of death of my daughter. I saw bleeding injuries in both cheeks of my deceased daughter. The village of my deceased daughter and the village and my village is intervened by a forest. So it is difficult to go to our village from the village of my deceased daughter at night. The elder brother of my son-in-law, namely Sada Sao, went to his sister's house the next day. He remained at his sister's house and sent information through the son of his sister to inform the incident to us. The name of that boy who informed us the incident is Pampered. It is about 20 weeks. But here for be cited as a charge-sheeted witness. Pampered. Thana Babu informed me that this case is on trial today and asked us to go to the court to depose if we like. My lords, may mark these lines, my lords. About 8 to 10 days back, Thana Babu went to our village and informed us to go to the court to depose. I did not inquire from Thana Babu regarding this case until Thana Babu informed us to go to court and depose. It is not a fact that the mother of the accused Dhadia did not tell us that her son Dhadia had killed the deceased daughter. It is not a fact that being influenced by Thana Babu, I am deposing falsely against the accused. It is not a fact that I did not lodge the FIR at PS. It is not a fact I am deposing false. My lords, I have taken to the entire evidence of PW 13, my lords. And my lords, as I have pointed out, my lords, it was on the first instance here that he has deposed about the appellant, my lords. My lords, may mark that is in cross-examination, para number 6 and 7.
All right.
And my lords, it is totally hearsay, my lords. And as far as the learned trial court, which has come to held to be a confession, which I will later on point it out, my lords, after I am done with PW 14, who is the mother of the deceased. Milords, and she was never an accused also, Milords. The deceased sufferer is my daughter. About 4.5 years back, my deceased daughter sufferer had married to Kunasau of village Nuaketa. We had given all our articles as per the demand of my son-in-law, Kunasau. My daughter Sufola died 1.5 years back in the house of my son-in-law, Kunasau. The deceased daughter Sufola was residing alone in a room. Her younger brother-in-law and mother-in-law used to reside in different rooms. My deceased daughter used to go to our village. My daughter used to complain that accused Dhadia used to come to her bedroom at night. She resisted the accused Dhadia several times. She entertained fears in her mind for the accused Dhadia. At that time, the husband of my deceased daughter was working at Qatar. The accused Dhadia attempted to commit illegal act, but due to resistance of my daughter, he was not successful. In previous occasions, we came to know that my daughter had been murdered at 5 p.m. and the matter was informed to us on the next day at 12 noon. Till 12 noon, we did not get any information from the house of my son-in-law. At the time of death of my deceased daughter, my son-in-law was at Qatar. At the time of death of my daughter, the elder brother of my son-in-law and younger brother of my son-in-law, Dhadia, sister-in-law of my son-in-law and his mother were present at home. Except them, none else were present in their house at the time of death of my daughter. The elder brother of my son-in-law, Sada, informed us that our daughter had died. Immediately, we asked Sada regarding the death of my daughter. He expressed his ignorance as to how our daughter died. Immediately, he went away without waiting any further to our home. We immediately went for village Nuaketa to see the deceased daughter. We started for the village after 12 noon and reached at village at about 2 p.m. We saw the dead body of our deceased daughter in her room. We saw injury in the person of my deceased daughter on several parts of the body, in face, in chest, hands, and other parts of her body. The body had already dried. The mother-in-law of my deceased daughter was present near the dead body. Sada and accused Dhadia were not present there. The mother-in-law of my deceased daughter caught hold of our feet and requested us to save accused Dhadia from criminal liability, as he is the author of the crime, Milords. This is the relevant portion, Milords. She further told us that her younger son, accused Dhadia, along with 4 to 5 persons, were taking liquor in the adjacent room of my deceased daughter. When my deceased daughter protested, there was hot exchange of words in between the accused Dhadia and my deceased daughter. Thereafter, for that grudge, accused Dhadia killed my deceased daughter. The accused Dhadia was drunk by that time. My sister-in-law arrived at home prior to our arrival. My lords, cross-examination. I have not disclosed this matter to anybody except today, deposing before this court. My lords may mark this also, same as that of PW 13, lords. I have not disclosed this matter to anybody except today, deposing before this court. We had given this incident in writing to Bantala Thana Babu. We had not inquired from PW, my lords, it is not visible.
Yes.
From the whether any case has been registered, my lord, it may be police from the PS, my lords, police station, whether any case has been registered. or not, basing on our report, as we were rustic villagers. Today, we came to court from our village. We were not cited as witnesses in this case by the police. On the day when accused Dharia took liquor along with his associates, on the very day he killed my daughter. There were 4 to 5 family members of the accused Dharia who were residing in that house in different rooms. The other houses are adjacent to this house also. I had not informed my husband that accused Dharia used to visit the room of my deceased daughter for illegal purpose, and that my deceased daughter resisted the illegal action of the accused Dharia. The accused Dharia did not visit our house, though he visited his sister's house in our village. Except myself and my deceased daughter, none else knows regarding the illegal and illicit behavior of accused Dharia towards my deceased daughter. By the time we arrived at village Noaketa, we saw the mother-in-law deceased was present near the body of my daughter. I had not disclosed this version of the mother-in-law of the deceased to anyone, as no such occasion arose, my lords. I had not disclosed the version of mother-in-law which I had read out, my lords, that the mother-in-law of the deceased daughter-in-law fell on their feet, my lords, and cried to save the present appellant, which I had just read in the chief, lords.
Right.
I had not disclosed the version of the mother-in-law of the deceased to anybody, as no such occasion arose. When the elder brother of my son-in-law, namely Sada, informed us the incident of death of my daughter, myself and my husband were present at home. When it is not a fact that the mother of the accused Dharia did not confess before me. My lords, may mark the word confess before me. Now I will draw my lord's attention to PW, the mother, who has been also deposed in this case, my lords.
Yes.
Regarding the fact that accused Dharia had killed my daughter, which the learned court has taken up to be as confession. My lords, it is not a fact that I am deposing by hearing the incident from someone else. It is not a fact that accused Dharia did not take liquor in a feast along with his associates on the day of occurrence. It is not a fact that accused did not kill my daughter. But here, I would like to draw my lord's attention to the fact that the depositions of PW 13 and 14, they have stated to have been an eyewitness to the occurrence, like they have stated in their chief and cross-examination. Whereas they were not present and they only turned up the next day after they got the information about the death of their deceased daughter at 12 noon, and they have made no allegation whatsoever, which is not on record also, Milords, and they come up for the first time here, Milords, and it was against the appellant, and they have, on the basis of the hearsay evidence, Milords, that which has been taken as confession by the learned court below, Milords.
All right.
When neither the mother-in-law of the deceased nor the father-in-law of the deceased have been added as an accused in the case.
Right.
I meant the mother-in-law of the appellant.
Right.
Just for the clarity, my lords.
Yes.
Lords, now I will like to draw my lord's attention to PW3, who is the husband of the deceased.
Yes.
It is at page 45, my lords.
Yes.
Well, I may be permitted to place it.
Yes.
I am locally called as Punna. The deceased Suppada is my wife. I know the accused person. My wife died about 1 year and 4 months back. I was present at Cuttack by the time my deceased wife died. I'm running a beetle shop there. After marriage, I had kept my deceased wife at Cuttack for a period of 1.5 years. At the time of death of my wife, she was at village Nuaketa. My deceased wife came to the village to see the paddy harvest of my landed property. I came to village Nuaketa prior to 12 days of the death of my wife. In the year 1998, at about 11 p.m. night on 26/3/98, I closed my beetle shop and went to the terrace for rest. At about 1 a.m. night, my younger brother accused Mandar Sau, who is the present appellant, Milords, Dodia alias Mandar Sau, went in a taxi and informed to go to our village. On query, he replied that my wife died at village by hanging herself in the room. Immediately, I came to my village, Nuaketa, along with my younger brother in that taxi. I saw at village that the dead body of my wife was lying on the floor of the bedroom. The rope was lying near the dead body. Small pieces of rope was hanging under the roof. Seeing the dead body of my wife, I became puzzled and went outside. I asked my family members as to why the deceased hanged herself. They simply replied that the deceased died by hanging herself, but they could not say anything the reason as to why the deceased died in that manner. My elder brother went to my father-in-law's house to inform them regarding the death of my wife. My father-in-law, Trinath Pradhan, and some villagers came to the village immediately on receipt of our information. Thana Babu arrived at our village at about 5 p.m. The dead body of my wife was lying inside the room by the time Thana Babu arrived in our village. Some ants had gathered near the dead body of my deceased wife by the time Thana Babu arrived there. The torn rope was hanging under the roof of that room when police arrived. Besides the rope lying near the dead body, it is an atu room. It has been terraced by me of bamboo and wooden planks. My wife hanged herself in a wooden beam. There were tin boxes, wooden boxes, one wooden something, my lords, I am not able to read, and one wooden alona with a tub in where the dead body of my wife was lying. The wooden bar was fixed 2 feet away from the cot where the deceased hanged herself. The length of the room is about 10 feet. The breadth of the room was 9 feet. The length of the wooden cot will be 6 feet, my lords. I'm sorry, 6 feet. The breadth of that
is it necessary for you to read every line of every witness? Why don't you make your submissions?
My lords, why I am impressing upon this fact, my lords, I will draw my lord's attention to the postmortem report, my lords.
That's all right.
So far in the cross-examination, he has stated that he had spent a lot of treatment of my wife and her small children after selling some landed property, but the child died in spite of medical treatment.
Right.
That is Thereafter, my deceased wife did not conceive for a period of 1 month. At times, she recollects regarding the death of her child and becomes sorry for the reason. Now, my
Right.
lords, I would like to draw my lords amendment to PW 15, the IO, my lords.
Right.
Now, my lords, the IO wherein PW 13 and 14, it is necessary for my lords to. My lords, PW 15 is the IO at page 73.
Right.
My lords, on 28/3/98, I was the OIC of Bantala Police Station. On that day at 3 p.m., I received a written information from one Mandar Sao, my lords, the appellant herein, that his sister-in-law Sufara had died by committing suicide on 27/3/98 night. On this report, I registered a UD case and directed the ASI B. Behra to take up inquiry. Exhibit 8 is the FIR of that UD case. Exhibit 8/1 is my endorsement and signature. 8/2 is the said UD formal FIR. ASI Brahmarabar Behra had held inquest over the dead body of Suphala Sao in presence of witnesses and executive magistrate. A. Ravind Rao.
Mr. Panda.
Arvind Rao.
Mr. Panda, instead of reading every line of this witness, please focus on those portions which advance your case.
My lord.
Make a proposition, then take us to that portion of the deposition which supports your proposition.
My lord.
What are you trying to say? Is there anything that this witness has said which throws doubt on the veracity of the other witnesses? 13 and 14.
My lords, that they had gone to him and they had tried to register their FIR against the present appellant, or they had heard from the mother-in-law of the deceased about the author of the crime being the present appellant, my lords. Nothing to that effect. As I brought my lords, PW 13 and 14, they have deposed only after a lapse of 2.5 about what they have heard from the mother of the deceased. Mother-in-law of the deceased, I'm sorry.
Right.
To that aspect, my lords, there has been nothing before the IO, my lords.
All right. All right. So there's no need, therefore, to read every line of his as to which constable went where and all that. That has nothing to do with what you're trying to argue.
My lords, what I wanted to basically press before my lord, that the entire evidence, my lords, which has been taken by the learned trial court to be held Evidence Act, my lord. My lords, this is a hearsay evidence, my lords, which is not admissible per se, my lords. The entire fact revolves around, my lords, that the learned trial court has held that the alleged statement of the appellant's mother is a confession.
Right.
But she is not an accused, my lords. How can there be a confession if she is not an accused? My respectful submission to that effect, my lords. And it was, my lords, also very much relevant that admissibility under the Evidence Act was to be gone into or dealt by the learned court below, my lords. Which was not dealt with. And I humbly submit that if so far as res geste under section 6 of the, it won't go under the res geste part, my lord. For that, my lords, I place one decision which is, my lords, 1996 6 SCC 241. This is Gentala Vijay Reddy, my lord. Was a state of Andhra Pradesh. Wherein in para 15 and 16, my lords, the principle of law has been embodied. My lords, may I place just one portion?
Yes. Please.
The principle of law embodied in section 6 of the Evidence Act is usually known as the rule of res geste, recognized in English law. The essence of doctrine is that a fact which, though not in issue, is so connected with the fact in issue as to form a part of the same transaction becomes relevant by itself. This rule is roughly speaking an exception to general rule that hearsay evidence is not admissible. The rationale in making the certain statement or fact admissible under Section 6 of the Evidence Act is on account of spontaneously and immediacy of such statement, my lords. My lords, their lordship has categorically stated that the rationale in making certain statement or fact admissible under Section 6 of the Evidence Act is on the account of the spontaneity and immediacy of the statement or fact in relation to the fact in issue. But it is necessary that such fact or statement must be a part of the same transaction. In other words, such statement must have been made contemporaneous with the acts which constitute the offense or at least immediately thereafter. But if there was an interval, however slight it may be, which was sufficient enough for fabrication, then the statement is not part of res gestae. Lords, here the entire evidence of PW 13 and 14 unfolded on the day they appeared at court and deposed, my lords, for the first time, which was after a period of 2.5 years, my lords. And they have also categorically, my lords, stated that the Thana Babu called them to the and the basis of the fact that whatever they have stated, they have not corroborated the same fact before the Thana Babu, who is PW 15, my lords, immediately after the occurrence. The fact that the statements have not been contemporaneous in this particular case, my lords, I rest my case with this judgment, my lords, which covers my entire case.
All right. Yes.
May I please, your lordship?
Yes.
Well, as your lordships have appreciated, this case has began on a UD case.
Yes.
UD case on the report of the brother-in-law.
Right.
Death has occurred 48 hours, the postmortem says.
Yes.
This occurrence took place on
98.
No, 98 date,
26 March 98.
Yes. After 24 hours, he comes to the police station to give a report, which is UD. After the postmortem report comes, my lord, the doctor is very clear. The doctor says it cannot be a case of suicide. Can I take a lordship to the doctor's? Your lordship is,
yes.
I can take to the very relevant portion, my lord, the doctor.
Yes.
Page 60, it begins, my lord.
Yes.
I'll read in 61. 61, cause of death, my lord.
Yes.
Death is due to asphyxia. Time since death, 36 to 48 hours.
Right.
Date and time of PM is 28/3/98, 11 a.m. So death must have occurred around 28/3, 27/3, 26/3.
Right.
Second para, while conducting autopsy over the dead body, I refer to inquest report. I have concluded after perusal of the inquest report and after conducting PM, injury number 3 is possible by violent action which are antemortem in nature.
Yes.
The possibility of suicide hanging is completely ruled out. My opinion that death is due to asphyxia is on account of forcible closing of mouth and nose. That is squarely responsible to cause death in ordinary course of nature. Injury number 5 is a resulting consequence of asphyxia. Cross-examination, my lord, it comes. Relevant portion, my lord. I'll read, my lord, just short one, I'll just read it. Suffocation may be possible if one drowns in the water. Asphyxia may be possible by suicidal hanging. I did not notice any finger mark in injury number 3 of PM examination report. One stops nose and mouth by means of hand, then finger impression may come. But if one uses cloth and other things, finger impression cannot be possible to cause asphyxia. I did not find injury on other parts of the body of the deceased except face. Regarding injuries in the person of the deceased in other parts of the body depends on the force used at the relevant time. I mean, ligature mark post-mortem in nature means there was a post-mortem ligature mark, my lord, means that the deceased was killed and thereafter hanged in the room. The ligature mark noticed is below the thyroid in a continuous process for which cut mark could not be visible. My lord, here, my lord, I would like to submit. My lord, as your lordship knows, in suicidal hanging, the ligature mark is always above the hyoid bone, my lord. In case of manual strangulation, it comes to on the hyoid bone, and at times the hyoid bone is fractured. If one tightens the rope in the neck before death, then ligature mark may appear. Multiple ligature marks may be possible, but one ligature mark would be antemortem, and the subsequent ligature mark must be post-mortem if the person is hanged after murder by means of a rope. It is not a fact that I have submitted a false PM report. It is not a fact this is a suicidal hanging case. Immediately after the post-mortem, I came to the office and prepared PM report, which I found in the dead body in the course. I have not prepared the PM report in the mercury as there was no space in it. I have not mentioned in the PM report that the nose and mouth of deceased were closed, causing asphyxia prior to her death. So, my lord, on a bare reading of the PM report, it shows that this is not a suicidal hanging. The ligature mark is post-mortem. Definitely, she has been done away with and she has been hung. Well, here, why the suspicion comes, my lord? Instead of confession that the learned court below has under section 6 of the evidence, my lord, the burden of proof under section 106 should have come on the family members, my lord, because this person, Mandara Sahu, he stays adjacent to the house. Immediate family, immediate adjacent room. The other family members are there, my lord. So, coming to the police station after 24 hours, minimum, my lord, death might have occurred before that also, my lord. And giving a false case of suicide, a clear suspicion comes to the shrouded in doubt, my lord, that there is some malified intention of getting this FIR registered as a UD case, my lord. So that is why the IO has said, after getting the report of the PM, he has converted it to 302. And of course, because no investigation has started at time, he has given, he did not know the accused and this is unknown. And he has given that unknown accused persons as unknown, my lord. Yes, my lord, it is also true, and I also consider the effect that PW 13 and 14 are a very belated stage, my lord. And that too, the learned court below court in his own wisdom has called for them, because definitely some evidences has come out, and the learned court below, knowing that the parents of the girl who will be in a better position to explain, they have come forward. And they have, both the parents have reiterated the same things, my lord, that he was earlier misbehaved, the daughter has told them. So they have also come out with a clear-cut motive. Of course, my lord, the husband has supported this only but natural, my lord. The mother-in-law has also said, my son-in-law is a calm-minded person. When we informed it that your younger brother is misbehaving with your wife, he did not say anything, kept quiet. So in this background, my lord, it is presumed that the husband of the deceased has kept quiet and not brought the younger brother into the scenario, my lord, as an accused. So if you take the evidence of the IO, the doctor, the father and the mother, my lord, a clear suspicion arises, and a burden under section 106 should have been dealt with the learned court below, my lord.
Right.
Your lordship can appreciate that. Definitely, this belated stage, the defense has a point there, my lord, that why have they did not go to the police at the initial stage, my lord. My submission will be they're illiterate persons. They ignorant about the procedure of law, my lord. So it was only when they have called, they candidly admit that the police babu told us that it is in the court that you can depose. So they have gone and deposed before the court, my lord.
All right. All right.
So I'll restrict that because.
Okay. Okay. Orders reserved. Both parties are permitted to file the respective notes. Mr. Pandey, you can also submit your note of submissions within 1 minute.
You are not clear, Mr. Pandey.
Audible now, my lords. Lords, am I audible?
Now you are audible, right.
My lord, including the cause of death, my lords. Implicating me is there is no evidence to that fact. Only to the fact that PW 13 and 14 in a belated stage. And if your lordship may see deposition of PW 7, she has also not said the mother that I have told anyone or any. Presumption of doubt to be also given to the accused lords. Because the entire evidence do not form a clinching part so far I being the author, nor can it be taken to be in any way admissible, my lords.
All right.
No, that is why, my lord, I'm not harping on this confession of the mother because.
Right.
But definitely there is a motive that
notes and submissions. Yeah. All right.
Mr. Junior Panda should come to court and do it.
All right.
I'm deeply sorry, my lords, for that.
No, that's all right. You give your written notes of argument. All right. Both parties to submit the written notes of arguments within 1 week. All right. Thank you.